Let's do it.
The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Massachusetts Appeals Court on this Monday, April 5th, 2021, our first day of April arguments. This, for the people watching on YouTube, this is courtroom A3. If you're looking for Judges Mead, Wolahojian, and Massing, you need to be on the other channel, A4. If you go back to YouTube and search for Massachusetts Appeals Court, that should be one of your options. But if you're looking for us, then you're in the right place. I am Justice Joseph Ditkoff. With me today is Justice Sabita Singh and Justice John Englander. We will have, sorry for the delay in starting. We had some technological troubles. Hopefully they won't continue. If they do, we will roll with them. There'll be a short sound check between each case, so we'll come off of the live feed for just a minute or two between each case, and there'll be a break about midday, maybe after the third or the fourth case, where we'll take a longer break, and I will announce that when it happens. We will have, the clerk will be replaced by a clock when we start. That will count down. Every once in a while, there's some trouble with the clock, but we are paying attention and we'll make sure that everyone gets their 15 minutes. I know all of you are familiar with the appeals court. There's going to be no rebuttal. We have read the briefs, we have read the appendices, and you can get right to your argument. And with that, I will call the first case, Commonwealth versus Marquez, 20P844. Attorney Harper Nixon, you have the floor.
Thank you, Your Honor, and good morning. For the record, Matthew Harper Nixon for Dustin Marx. I'd like to start with the sufficiency argument. This was, I would suggest to the court, one of the rare cases where the evidence proffered by the Commonwealth, primarily through Trooper Dunderdale, who was their expert on intent to distribute, actually pointed to the equally to the opposing propositions that the substances found in Mr. Marx's jacket, which were the subject of the trafficking charge, were either intended for distribution or intended for his own personal use. And this is a case I would suggest to the court where the question isn't whether the jury got it wrong. The question, of course, is whether it should have gone to the jury in the first place. And where here the evidence of intent to distribute was, I would suggest, quite weak. And there was some substantial evidence through the trooper's own testimony and the testimony of the other officers that these substances could well have been intended for his own personal use. In equipoise, they do point equally to either proposition. And in that, again, rare circumstance, the Commonwealth cannot have been said to have met its burden, and the case should not have gone to the jury in the first place.
Are you saying that the jury would have had to employ conjecture to arrive at the Commonwealth's supported theory?
I think that is the nature of the Croft proposition, Your Honor, in that where you do have these equal propositions, it by necessity implies conjecture, because there simply isn't enough evidence to support. And I recognize that this is not a circumstance in which I'm saying the jury got it wrong. The issue is the Commonwealth does have to get over some bar of sufficient evidence to get to the point where it should be submitted to the jury. Frankly, I've handled a lot of drug cases in my career. You generally see much more evidence of intent to distribute. And even if there is some evidence of personal use, the evidence of intent to distribute far outweighs it. You see small packaging, you see testimony, or you get testimony about people coming and going, hand-to-hand transactions, simply just a lot more. And I think it was interesting that one of the sort of issues of the testimony here with Trooper Dunderdale on cross-examination and recross and redirect was that there was some questions about, say, for instance, multiple cell phones or drug logs, things that you would, again, normally find in a situation in which you're seeing intent to distribute.
Yes. We can grant you, maybe, I can grant you at least, the concept that you usually see more. But the question for us is the Lattimore standard, and here you have the testimony of a police expert saying that it's a very rare case where somebody has 28 grams, that they're not going to be involved in trafficking. I mean, I'm paraphrasing, but that's essentially what the expert said, right?
He did.
How
but,
is it that given that, how is it that given that testimony, which went in, I don't see any argument that it was not competent. How is it that that's not enough?
Well, if that were all that there was, Your Honor, I would say maybe it would be. But we do also have his own testimony that sometimes users would use up to 5 grams of heroin a day. That is his testimony as to the half of a finger. It's a little bit, you have to parse it a little bit, but he does testify to that. And so the notion that
didn't your client testify that he got it down to $35 a day, that was why he, I mean, wasn't that your client's testimony? $35 a day is not five grams, is it?
No, of course not. But I think that was his testimony, as I understand it. My memory is that was his testimony as to what he did when he first started using heroin. He also testified that he would use up to 5 to 10 grams a day, which of course would be well more than $35. No question about that. My understanding is a gram is approximately $100, depending on how you look at it from street prices. And then, of course, there's a testimony that he's buying in bulk, and that was his whole proposition. I would,
but even so, 5 grams is not going to be $35.
No, of course not. Absolutely not. Absolutely not. But my understanding is that his testimony was he was sort of describing the progress of his addiction, which was
what
that
do
he
you
first
say
started
to
out.
The Commonwealth makes an argument. They do some math in their brief, and they say, hey, if he's doing 5 grams a day on $50,000 a year, where the heck how's he managing that? Just as a matter of math.
Sure. Again, I don't know the answer. There wasn't any testimony about what his job prospects were. He testified to what he was making in his actual job. Of course, people have jobs off the books. I understand that point. But again, I would suggest that we are looking as to whether or not there was sufficient evidence to give the case to the jury. We just didn't have that here. But I recognize that once the case goes to the jury, they're, of course, free to believe anyone they want. And I would frankly suggest that the jury, for purposes of the discussion of sufficiency, we don't even have to look to Mr. Marx's testimony. It's my issue is with Trooper Dunderdale's testimony, that he himself presented evidence of either proposition. So I would suggest that there's not sufficient evidence here. So I'll move on to the motion to suppress. And I recognize that this is a little bit complicated, so I'll try to just take it in pieces as we go through the judge's decision. The primary argument that the Commonwealth put forth to support this warrantless entry into Mr. Marx's home was that it was a voluntary entry. That Ms. Leiden, who was, for purposes of the motion, I think reasonably a resident there, gave over her key, and then the police were therefore allowed to go into the apartment and ultimately arrest Mr. Marx. I think that the issue with that decision by the motion judge is that it was the Commonwealth's burden to prove that decision by Ms. Leiden to give over that key was voluntary. The act of giving over the key in and of itself is not proof that it was voluntary. We have to look to the individual characteristics of the person making that decision. And here we have a woman who, by the testimony of the police at the motion hearing, was upset, crying, apprehensive. Apparently her father was a Massachusetts State police officer who had seemingly brought her to that police station that evening. I think the testimony was that her mother saw some bruises, and then she went to she was then brought to the police station. I think it may have been in the grand jury minutes as opposed to the actual live hearing. And then, of course, we have her comments in the grand jury hearing, which were before the motion judge, that when the police asked me for the key, I had to give it to them. I didn't want to, but I did. And ultimately, the question is, was this a voluntary decision by her to hand over this key and allow the police to go into the home? Or was it
argument? It seems to me this argument amounts to a contention that the Commonwealth has to go beyond the act of providing the key and provide evidence that they told her she did not have to give it to them.
Not necessarily. I don't think that's necessarily true. I can certainly
envision what's missing then, because
sure,
Commonwealth, she says, I have a key here, take the key. The judge finds as a matter of fact that she gave it over voluntarily after hearing from the police officer. How do we get around a finding of fact after hearing from a witness without something like an obligation to prove that the officer said to her, something else, like you don't have to give it to me.
Sure. No. Well, first, my understanding is that the judge is actually making a ruling of law here. That action that she gave over the key is a voluntary action. Now, maybe it's a fine line, perhaps. But and to get back to your question, Justice Englander, about what else you could do, certainly it's very easy to envision a set of circumstances in which someone goes into the police department and says, "Hey, this thing's happening in my home. Please go in there and stop it." In that set of circumstances, you wouldn't need any testimony that the police gave them the option not to. That would be an affirmative action by that person giving over that key voluntarily. And where that's the case, then that's a voluntary action. I think the Commonwealth has met its burden there. But here the judge says that he's looked at the testimony in the grand jury and says that he finds that is not proof. He actually says there was no proof of coercion, where I think frankly, the Commonwealth has to prove there was no coercion. He's almost flipped the standard a little bit here. But
how did the issue of the key even come up? Right? There wasn't a request. Do you have a key? Give us a key. According to the testimony that the judge heard, she volunteered. Here, I've got a key. There was no request. Was there?
It's unclear. I mean, her testimony certainly to the grand jury was that they said, "Give us the key." The testimony of the officer at the hearing does sound like it says, "Hey, here's a key." So that is, to the extent that I suppose there's a credibility determination there. Maybe there is some credibility determination being made. But I would note again that in the judge's decision, his position, as stated in his written ruling, is that her testimony to the grand jury did not amount to coercion. He doesn't say he's making a credibility determination there. So to the extent that he's making a decision based on whether her testimony was, or excuse me, whether the Commonwealth met its burden that this was not a coerced act, I suggest that that's an error of law as opposed to a finding of fact. Obviously, if it's a credibility determination, this court has no basis to overturn that. I recognize that. I wouldn't argue that. And if it's a finding of fact, it would have to be clear error. I'm not arguing that either. I'm suggesting that his determination that the testimony he heard at the hearing combined with the testimony he received from the grand jury minutes did not offer proof of coercion, or did not, at the very least, allow the Commonwealth to meet its burden of showing this wasn't coerced. That was an error of law.
The testimony was someone walks with a police officer, says, "Please come into my house and arrest the abuser in it." That the Commonwealth would be required to show some affirmative evidence of non-coercion in that situation?
I'm sorry, just so I'm clear on the question, just as I apologize.
The testimony is someone walks up to an officer in a detail, says, "Please come into my house and arrest the abuser in my house." The Commonwealth have to show some affirmative evidence of non-coercion in that situation.
I don't think so. I think if you have that level of testimony, that would be enough. I think if you can say affirmatively that this person walked in and said, "This is happening, please stop it," that's a voluntary act. I don't think that's what happened here. On my reading of the record, that's not what happened.
But how do we know there's a difference between the hypothetical that Judge Ditkoff just gave you and what we have here? Because it's certainly a reasonable reading of both the testimony. Let's just leave aside the grand jury for a moment. Certainly of what the judge found. It's a reasonable reading of what the judge found, that it's exactly what Judge Ditkoff just asked you. How do we know this is different?
Well, we have to look at the testimony. We have to look at her testimony to the grand jury. We have to make that determination as a matter of law.
And the testimony to the grand jury that you rely on was what? What exactly did she say, in your view, that changes things?
I have to pull it up here. One moment, please. I have it here. Pardon me. So as I have it in the brief, this is in the record appendix, so I point the court to that if necessary. It's in the impounded appendix. She was asked about giving the police to the key. She responded, "I didn't want to, but I did." The prosecutor followed up, and this is a couple pages later, or sorry, the same page. "But you did give them the keys to the apartment." And she responded, "I had to. They asked for them." Yes. And so that's what I'm relying on, her own statements, to say that they said, "Give us your keys," and she did. Now, granted, I will agree that I don't think the Commonwealth is required in every instance to say, "But Ms. Leiden, you don't have to give us your keys, just so you know." That's fair. That's fine. But I hesitate to read that in any other way to say that she felt like she was.
Why do we have to accept what she said to the grand jury many months after she had the conversation with the police officer that was testified to at the suppression hearing? And
well,
which findings made? I mean, the judge is free to to accept what the police officer says is accurate as opposed to what she said to grand jury, right?
If he's making that decision, yes. But again, his written decision says that the testimony that she gave to the grand jury does not amount to proof of coercion, and that's what I'm taking issue with. And so,
well, perhaps what the judge is really saying is, even in her grand jury testimony, she did not indicate that the police did anything to make her feel. She simply said, they asked me for the key. I gave them to, she's reflecting something internal. I felt I had to give it to them. There was nothing that she offered in terms of how she was asked the question, what specifically, to indicate that they did anything externally. So there's not necessarily even any conflict between what she's saying to the grand jury and what the officers are telling the judge. There's not necessarily any factual conflict, except that to the grand jury, she's expressing what she feels internally, which the officers wouldn't have been able to testify to or recognize necessarily.
As far as the officers in that moment, yes, I would agree. And I would agree that there's nothing here that says that they strong-armed her in any way or were looming over her or something along those lines. I understand that. But this gets to the Egan case from this court, which suggests that we have to look in this determination to the individual characteristics of the person. This is not somebody, it seems, and we have the testimony, this is someone who was crying, upset, apprehensive. This is, of course, on the day of the interaction with the police. And apparently didn't want to be there. But again, her father's a police law enforcement officer. Her own testimony to the grand jury, in my mind, points to an acquiescence to authority. That they said I had to do it, I did it. And of course, the contrast that I suggest is with the Egan case, where you have the Brookline police officer who knows full well that when the police ask him, hey, can we look in your trunk? He's perfectly entitled to say no. We, of course, all know that too. But this upset young woman in this Taunton Police Department in the evening of, I think it's Thanksgiving, by all accounts, it seems to me, did not. And so that is the question that we have to look to as well, her own individual characteristics. And of course, it's a backwards looking decision. I mean, that's the nature of a motion to suppress in some regards. I see that my time is up. I apologize.
I know your time's up. I do have two brief questions. One,
Sure.
Am I correct in thinking you're not challenging the assault and battery conviction, though you would like it resentenced if you prevail on the trafficking?
That's correct. I suggest there's a sort of a package sentencing situation there, but no, I have no appellate challenge to that.
And can you point to me anywhere where you preserved the argument that the search, if the entry was okay, was illegal?
The search of his person, you mean? I'm sorry.
I mean, I saw below that there were many arguments about the entry and how it was illegal, but I didn't see anything where the challenge of the search once the entry happens. Is there any to me too?
Well, I will certainly acknowledge that it wasn't the focus of the hearing. The focus of the hearing was the voluntariness of the entry. That being said, the judge in his ruling did address the issue, both particularly in terms of the search of the jacket, and found that it was a search incident to arrest. And so this court, I think, is perfectly free to review that decision of law. I think it's de novo as a standard. Because the judge did rely upon that in his own findings. If he hadn't found that, I wouldn't say it was preserved. But having taken that step of doing so, I think it's perfectly appropriate to review the circumstances that we are aware of, both between the testimony and the police report that was put into evidence, and determine whether or not that was an appropriate finding by the judge.
All right. Well, thank you very much, Justice Singh, Justice England, or anything else? All right. Well, thank you very much, Attorney Harper-Nixon. And now we'll hear from Assistant District Attorney Stern.
Good morning, Your Honor. Shoshana Stern for the Commonwealth. I apologize in advance for my allergies, but fortunately, I'm very far away from all of you. Your Honors, to, I guess, go in the order that the defendant did with regard to sufficiency, as I argue in my brief, the facts here are not at equipoise in the light most favorable of the Commonwealth, or even taking into account the defendant's testimony. And I think cases have reflected that situations in which there is genuinely equipoise are fairly, I don't know, scenarios in which it is genuinely an equipoise are fairly rare. And in this case, the expert testimony by itself would put that over the rail, combined with the quantity. And there was additional evidence on top of that in terms of, the scale and the baggies. And I know the defendant essentially testifies that he was essentially distributing to himself in his use of those items. And I mean, the jury could have believed him. He was entitled to testify to it. I would argue it was reasonable not to believe him, but for the purpose of sufficiency, that things they could have believed but didn't have to would not factor in any event. With regard to the entrance into the apartment, the judge found a number of grounds in favor of proper entry, but the primary one was the voluntariness, which I would argue, I mean, again, he made findings of fact where first of all, he appeared to credit that she offered the key to the officers. And in addition to that, I mean, which is sufficient, as he noted, they did not need to tell her she had the right to refuse. And I think he properly found that even if you were to apply a standard of fully crediting her grand jury testimony in the light most favorable to, I guess, the defendant, nothing she said actually took it out of the realm of voluntariness. It was more of a description of her internal processes, which, I mean, again, she may well, as I noted in my brief, she may well wish she had additional choices, but that does not.
Right. I understand that at the time, her father was a former state trooper, but the suppression transcript doesn't say that. It says he is a state trooper. Do we have to take that? Or maybe I'm missing something. It certainly says that. It might say something else elsewhere.
I missed that fact. I believe it said former elsewhere in the record that was at the suppression, but I admit that I, possibly because I knew what else was in the record, I didn't realize that. I mean, there was testimony from the officers, again, about not knowing that about him one way or another at the time that he was there, and they talked to her, that they found out later. So I think the fact that it wasn't a fact, they testified it wasn't a factor, regardless of what it was, essentially would carry the day. And I mean, even assuming there could be some significance specifically to whether he was former or current. I mean, I don't know if he.
I wonder, do we have to take the father as a state actor for these purposes?
I admit I had not thought about that, but because again, my understanding is that he was not, in fact, a current state trooper. And I mean, there was a variety of testimony in terms of his role in bringing her there and the extent to which it was, you know, that he was instrumental versus assistance at that time. But I would think that given the testimony about the entirety of circumstances where she was just presented as a victim, that she presented at the station and spoke to the officers and they were not aware of anything with regard to her father. And I mean, presumably his role as her father would have more to do with why she would defer to him in coming there. And the actual police officers who effectuated all of the proceedings in this case say that they were not aware of his status at that juncture, that it wouldn't really factor in.
Back to something you said a few moments ago. I mean, surely if she says, I had to, that's enough for a finder of fact to have come out the other way had they chosen to.
I mean, I suppose.
I mean, you said something about, you know, maybe she had, or something about having no other choice as being, you know, okay. It's not okay. I mean, if she felt compelled to provide access by the police officers, it's not consensual, right?
I mean, I think I overstated what I was essentially. I was trying to suggest that the judge was correct that not all of her statements about what happened would actually suggest that she was in any way coerced by the police as opposed to unhappy about her situation. But I mean, I'm not, that's not to say you're correct.
That testimony may in fact have been in equipoise. You have the situation where the judge is watching the witnesses, right? I mean, back to something else.
Yeah.
I mean, you said, you know, you kind of went through the sufficiency argument and you leaned, as you did in your brief, on the testimony of the expert, and I totally understand that. But didn't the prosecutor help him along a little bit by saying things that weren't really in the record?
He
isn't doing 28 grams a week and living.
Oh, you mean in the closing argument? I mean, that's a separate. I mean, that does not go to the sufficiency of the evidence before the
No,
jury.
it doesn't. It goes to the question of whether, given a case that was relatively close, because I accept what your brother says, that this is less evidence than we usually see.
Mhm.
Given a case that's relatively close, the prosecutor says two things that bother me. One is 18 grams is sufficient to prove distribution. That's just an incorrect statement of the law, right?
I thought he said to prove trafficking, which is not, I mean, there are other
He
issues.
may
with
have
that.
said to prove trafficking. Either way, it's wrong, right? Because there has to be an intent.
Yeah, I mean,
Just
again,
having 18 grams does not prove it.
and I mean, I agree. As I had argued in my brief, that essentially the fact that, the fact that it is enough to be trafficking weight is of some relevance, just in terms of that's a lot of drugs. But I
Right, he should have
essentially,
used the word fine. 18 grams is sufficient to fine.
yeah,
Not
no,
prove.
certainly.
He used the word prove. Someone should have interrupted and said, that's not right. And then he goes on and says he isn't doing 28 grams a week in living, and there's absolutely no evidence on that, right?
There's
Did he
evidence.
just misspeak?
I mean, I can't, there was evidence essentially, and I think it's unfortunately at this point somewhat known that heroin, particularly with fentanyl mixed, is inherent. It is very dangerous. But yeah, no, I mean, again, I didn't,
Well,
I'm
I
not saying
certainly
he should have
don't know
said it.
that. I mean, there's evidence in the record that he's
Yeah.
doing 5 grams a day. That's 35 a week. I don't know whether that's at
Yeah, I
all
mean-
reasonable. It does, it strikes me as rather extraordinary, but because it's
I-
also
I-
several $1,000s a week.
I mean, again, it was in a paragraph, which, as I argue, contains some obvious hyperbole. And then he goes on to, in the rest of his closing, go through all the specific reasons based in the evidence that the jury should find the intent to distribute. So I think he's clearly not intending for the jury to just be like, aha, we're done. And they were very carefully instructed by the judge, who gave instructions both before and after the closings. I think she actually specifically said she had a commitment to getting everyone to do it that way because she thought it was better for the jury's attention. But she was very clear about the fact that the attorneys are not witnesses. Don't believe anything they say that isn't essentially you didn't hear from as evidence. But so I think again, I didn't, I think, say that it was an ideal thing for him to have said, but I think in the totality of what he said, it would have been clear to the jury that the important thing was the totality of the specific evidence that they heard. And again, when people speak on their feet, things happen, but certainly, again, I'm not saying that was something that should have been said. But also, the jury heard the evidence and they might have said, they may have had your reaction. They may have said, wait a second, that's not what we heard. But in terms of, again, that it being over equipoise, you have Trooper Dunderdale's testimony, but you also have, frankly, I think one could certainly argue that the defendant's testimony in the aggregate was sufficiently inconsistent, both with his own story and with the expert evidence, that it may well have solidified the jury's impression that there could not be a personal use explanation from this because he wasn't giving a super convincing one. So that is a factor too. There further questions?
Counsel, do you agree that if the evidence on his person is suppressed, you don't have enough for a trafficking charge?
No, nothing was seized from the apartment. there was evidence that I think, and by his own admission, he was doing drugs at that time. But yes, there wasn't, certainly not trafficking by definition, because there was there was only, I guess, a question of whether we could somehow prosecute for the line on the table, but it seems unlikely.
Is there a reason you don't argue that the arrest is also an arrest for possession of narcotics?
That didn't occur to me until I reviewed the case law last night. And I did notice that there are cases, though I can't think of any off the top of my head, that state that even if you're arresting for another purpose, when there is probable cause of possession of drugs, that can factor into the search incident to arrest in terms of what's being searched for. Another thing that sort of, I addressed the defendant's claim that there wasn't a sufficient reason to fear the defendant for the purpose of the weapon search in my brief. But in fact, I mean, this is not a Terry search. The statute is that you search, if you're arresting somebody, you can search them for weapons. And there's a lot of case law on, you know, how far can you go outside of the person? But I didn't really see anything sort of suggesting that you have any particular burden for searching, you know, the person's coat pockets.
My understanding of the Supreme Court law on search incident to arrest is if you're arresting somebody, you get to search their person. Am I missing something?
No, I think that you were correct about that in the, yeah, I think that I mean, again, I didn't.
I mean, your brother seems to be arguing that there's some limit to the scope of a search incident to arrest. Or alternatively, I read your brother to argue that even if you can claim that you can do a search that's complete of this person, you need some sort of administrative authority to do it, you know, sort of like a, you know, one of the inventory search kind of ideas, neither of which I am aware of being in either the case law of the US Supreme Court or the Massachusetts SJC. If someone wants to educate me on that, that'd be great. But my understanding, of course, you get to search the whole person because you don't put somebody in a car behind you without knowing whether they got a gun.
I agree, but we seem to have lost Justice Singh.
You seem to have lost her.
So I have some things to say, but I will hold off.
Yeah, let's pause. It's 2:40. Matt, do you see her?
I don't see her in the waiting room.
All right.
Here she comes.
Reappearing.
I believe it was 2 minutes and 30 seconds, Judge. Should I put it at 3?
I had 2:40. Yeah, I put it at 3. We went a little over with Attorney Harper Nixon anyhow.
Oh, do I start or do I wait for the clock?
No, wait, please wait. We don't fully have Judge Singh yet. We've had some problem with this step before. It's why we were delayed in the first place.
I think I should put the judge back in the waiting room and then readmit the judge.
Yeah, let's try that.
The judge should be joining soon.
I can hear everyone.
Oh, you can. All right.
Nice, Sabina.
That's all we absolutely need. All right. Well, Judge Singh,
Perhaps you should just continue because I've got the audio.
Yeah, if you can hear us, then we can keep going.
Okay.
All right, I'm going to click and then I'll click record and say we're recording and put the timer at 3 minutes.
Wonderful. Thank you, Matt.
All right.
I think I just asked a question that was way too long-winded, the gist of which was, what am I missing about whether there's any law that limits the scope of a search incident to arrest?
So, I mean, there's law that limits a variety of parts, but I think as far as what you're getting at, you are correct. I mean, there's law certainly about wingspan. There's law about if you get too close to a cavity search, at which point you're presumably not searching for weapons anymore most of the time. But in terms of, and I think that my brother is correct about there being some limitations in terms of what evidence you can what crimes you can reasonably expect to find evidence of on a person. But with regard to weapons, I have not found any limitations. Certainly the language of 276 section 1 doesn't contain any. And there is case law saying that that's all you need. Now, that's not necessarily dispositive by itself.
No, I mean, no, it's got to be unlimited. It can't, well, except for like cavity searches, but it can't be you can only search for weapons, because then we won't wind up in a debate about whether the scope of what they did was beyond what they should have when they found drugs instead of weapons. You know, I mean, a search for a weapon, that could be, you know, a pocket knife, right? I mean, we're not going to limit it, except, I don't know. I just don't think that there are many limits in the case law.
Well, I'm certainly not going to urge you to find any limits that you don't feel are supported by the case law, particularly adverse to us. But I mean, I think that there's like, you know, there's a case where they found a prescription bottle and they could seize the bottle, but they couldn't open the bottle because there wasn't really a bottle. That's
that I get.
Yeah.
Okay.
But where there can reasonably be a weapon, I think you are entitled to search.
You're referring to the White case?
Probably, yes. I'm not great with case names.
Fair enough.
You need Mary Lee for that. But yeah, so yes, I essentially, for this purpose, I would agree with you, Justice Singh.
Okay, so, well, that's interesting. Okay.
Did I cause a problem?
Well, no, because I mean, then that leads to this following question. You pat somebody down and you find a lump. Does there have to be proof that the lump reasonably could be a weapon before you can continue your search?
I have not. I think when it, at least unless it's completely soft, I think usually in the cases, and certainly that was what the officers were thinking here, you don't know what it is if you find a hard lump, and at that point you need to look further, essentially. I mean, maybe if it's a tiny lump, but that I think in general, if you find a hard object of an unknown identity, at that point you're entitled to go further to find out what it is in this sort of search. Well, actually,
but it's an interesting question.
If there are no further questions,
All right.
Commonwealth rests on its brief. Thank you, Your Honors.
Thank you both. Great briefs, a great argument, very helpful to the court. Attorney Harper Nixon, I understand from your stay briefing that your client is getting treatment for his substance use issues, and I think I speak for all of us when we wish him every success with that. And thank you both.
The case is now being recorded.
All right, we're back on the record. We'll call the second case, Commonwealth versus Perez, 19P 1672. We'll hear first from Attorney Brennan.
Good morning, Your Honors. My name is Attorney Paul Brennan. I represent the defendant, Frankie Perez. Mr. Perez was convicted of possession of a firearm, is enhanced by, as the judge found, by at least 3 qualifying predictions, which constituted, which rendered him to be an armed career criminal. Before I get to, which probably is the main issue in this case, is the armed career criminal enhancements, I would just quickly like to address the issue of the ineffective assistance of counsel with respect to the jury question. The jury came back with a question about whether or not Mr. Perez had been previously convicted of the crime. I contend that defense counsel was ineffective in not requesting an instruction to tell the jury that to the extent that they have any such recollection of the evidence, they were to ignore it as it was irrelevant. Neither defense counsel or the judge gave such an instruction. I contend that the justification for not doing so, that it would draw attention to the issue, was, well, doesn't seriously.
Was the instruction that you're saying should have been given, was that even requested?
No, it should have. Well, I'm saying it should have been given. No, it wasn't requested, and the judge didn't give it. And judge just told him to the extent that.
Why would you say to the extent you recall such testimony? Why wouldn't the instruction simply have been there was no such evidence? I think any such thought.
I think case law. I was careful to rephrase how I phrased the argument, because I think case law says that the judge is not to tell the jury what the evidence is. So my contention is that, well, I would have been happy with such an instruction, but I think the case law is that he can't tell the jury what the evidence is, but he could tell them to the extent that there was, if they did have a recollection of such evidence, they were not to consider it, and because it was prejudicial. And so the only question is not whether it was wrong. It could be justified as a trial tactic not to request it because it called attention to it, et cetera, et cetera. I think that's a supercilious argument. The only question is whether it was prejudicial or not, in my mind.
Well, counsel, could you remind me again, what are you contending would have been the appropriate way to answer that question?
Appropriate for the judge to say, to the extent that any of you have a recollection of such evidence, you are to ignore it. And
what was said in this case? The evidence is closed.
Oh yeah, the evidence is closed. That's it. So in other words, your memory shall guide you, or something, or words to that effect. When it should have been, you're to ignore it. That would have been the proper instruction, and therefore the risk is that the jury would have then rendered the verdict based upon a misconception that they could consider evidence of whether or not the defendant evidence that the defendant had previously been convicted of the crime. I don't know how.
You're saying even though there was no such evidence, there was a risk that maybe they believed it?
Yes, because what happened was police officers testified that they knew him from the neighborhood, and I think that maybe they deduced that, well, if they knew him from the neighborhood, maybe he'd been arrested before.
They played softball with him.
I'm sorry? No, two officers said they knew him. Two officers said they knew him.
Right. One of whom played softball with him.
So
the jury could just as easily have deduced that the other guy knew him from softball as well.
Well, what is concerned is the jury question indicates that they did believe, well, for whatever reason, they did believe that there was a risk that believed he had a criminal record for whatever reason. And I contend that that instruction should have been given to obviate the risk that they would consider that such evidence, and I'm sure that the Commonwealth conceded such evidence would have been inadmissible, not relevant, and therefore it was prejudicial. Now, if I might move on to the ACC issue, which is probably the reason why we're probably here. First of all, the Commonwealth has conceded that there's, with respect to the two assault with a dangerous weapons issue, the two convictions for assault with a dangerous weapon, only one of them should be considered because they weren't sequential prosecutions. The Commonwealth conceded that. So if we know, and I can respectfully submit that the only one that that survives is the assault with a dangerous weapon by means of use of an automobile. So I will concede that that is a valid predicate conviction. Therefore, the issues, the other convictions that are before this court, that is the assault and battery on a police officer and assault with a dangerous weapon, there are 2 counts of assault with a dangerous weapon constituting 1 predicate conviction, and one conviction for assault and battery on a police officer. So that makes 2 predicate convictions, which are.
So just before you continue, make sure I understand this. You're accepting the Dudley District Court ABDW automobile as a valid predicate, and you're challenging the ABPO and the ABDW shot foot door thing.
Yes, correct. Yes, sir.
Okay.
Okay.
And we all agree that the gun doesn't work.
Yes, yeah, because it wasn't a sequential prosecution. The Commonwealth considered.
So there are 3 potentials, one of which you agree to, the other 2 of which you don't agree to.
Yes, correct. So if my arguments are successful, you would have 1 remaining ACC.
So you'd be looking for a remand for a resentencing because there still could be an enhancement on the basis of the 1, right?
Yes, that's correct. Yes. Yes.
Okay. So let's try to cut to the chase if we can, and because I have some understanding of what's going on, I think, and maybe we can cut to the chase. You make an argument to the effect that both of those were pleas. Both of the 2 that you're challenging were pleas, and that the evidence that was put in can't be sufficient to show violence for purposes of the ACCA because it didn't relate to what was said at the plea colloquy.
That's one.
Right?
That's one argument. Yes, correct.
It seems to me to be your principal argument. If there's another one, let's just stay on this one for a moment. Okay. Do you have any law that suggests, because now we're outside of the federal world, right? In the federal world, we don't do this at all because we can't.
That's correct.
So do you have any law that suggests that in determining for purposes of the ACCA, whether there was violence, if there was a plea, you have to put in what happened at the colloquy.
All right, well, there is no, I concede that there is no case on point that says explicitly what I'm contending here. However, I would point out that there's some ambiguity in the case law enunciated by this court in Colon and in Eberhardt and Wentworth about what the evidence should be at.
What about Ashford?
Well,
The case that helps you immensely. It hurts you on this, doesn't it?
No, I don't. They all say this basically the same thing, Your Honor. First of all, they all start with they've all taken the footnote number 8 in Colon and say, and I'll just quote, at the subsequent offender trial, the trial judge may admit any evidence that would have been admissible at the original trial of the alleged predicate offense. Okay. However, that at the bifurcated trial, nonetheless, it still remains the fact that the Commonwealth has to prove what was the basis for the conviction. So in other words, yes, they say on one hand, yes, you can, any evidence that was admissible at trial can be used at the bifurcated trial, but at the same time, they have to show what was the basis for the conviction.
Counselor,
Well,
go ahead.
No, go ahead, Joseph. Sorry.
At a plea colloquy, the prosecutor, reads the facts, the defendant agrees to those facts, and those facts are based on what the officer told him. So now that we hear what the officer says, why isn't that pretty good evidence? Evidence that at least a finder of fact could find establishes what was said at the colloquy.
Well, first, in this case, there wasn't any such evidence. All that happened in this case was the Commonwealth called the two convictions that are issued here is the assault and battery on a police officer and assault and battery with a dangerous weapon. All that was at issue was all the only evidence that the judge heard was the facts of the alleged facts of the case, but there was no evidence about what was recited at the plea colloquy. Now, I note that in the Commonwealth has appended certain Rule 128 decisions in its brief, indicating that, well, we do this all the time. We just call the alleged victim, testifies about what happened, and that's enough. We don't have to talk. We don't have to prove what was at the plea colloquy or what occurred at the trial. However, if you look at the first case that was appended, Commonwealth versus Davoran, I'm hoping I'm pronouncing it correctly. It was a lengthy decision, but what happened in that case? Yes, there was some testimony from the alleged victims or witnesses, but it was to supplement what was stated at the plea colloquy. It was a very lengthy decision, but
and you're saying here we don't know precisely what the defendant agreed to as being the basis of the charge.
Sure, yes, that's what I'm saying. So the prosecutor said, officer, were you at the plea colloquy? And he said, yeah, I was. And can you tell us do you have the police report with you? Yes, I do. And was that police report read at the plea colloquy? Or they could have had somebody there to testify about what was stated at the plea colloquy. And then, of course, I would concede, at least for the purpose of this case, they could then have called the police officer to give additional testimony to supplement the evidence if they think maybe there was some additional evidence should have been submitted or to supplement the plea colloquy. That wasn't done in this case. All we heard was that Mr. Perez had been convicted of assault and battery on a police officer, and he had also had 2 convictions for assault and battery with a dangerous weapon. And you heard testimony of the police officers about what happened on those occasions, but those police officers did not testify or nobody testified about what was what the facts were, or what facts were recited at the plea.
So it's funny. I mean, your argument, it seems to me, depends on something that you've said a number of times, which I don't think we find in the cases, which is that he can only be enhanced for something that was the basis of the conviction. You keep saying the basis of the conviction, and then
Yes.
you use that language, the
Yes.
basis of the conviction.
Yes, that's indicated.
To
That's
say you have to look at what was agreed to at the plea colloquy. But in fact, the language of the statute says having been previously convicted of a violent crime. So if someone comes in and proves that it was a violent crime, why do we, based on the statute, have to know what was said at the plea colloquy?
well. First of all, I'm glad you have raised the statute. The chapter 278 A section, so 278 section 11A says the defendant's entitled to a jury trial on the question of a conviction. It doesn't say the facts of the conviction. It says whether or not he's been previously convicted. So my contention is that, and I would suggest that if you take the language of Colin and Eberhardt and Wentworth, and they all acknowledge that you have to show the basis for the conviction and the legal theory upon which the conviction was based. And therefore, you have to make at least some showing about what was said at the plea colloquy or what evidence was adduced to trial. I would just draw your attention to the language of United States versus Harris, which was quoted in Eberhardt. And I would just, this is what the SJC quoted. It would be appropriate for the sentencing court to look at the conduct in respect to which the defendant was charged and pled guilty, not because the court may properly be interested in this context in the violent or non-violent nature of that particular conduct, but because that conduct may indicate that the defendant and government both believed that the generically violent crime rather than the generically non-violent crime was at issue. In other words, in the SJC,
that language is almost impenetrable to me. I have to say, it really is. I don't understand what they're saying there. I do understand your argument, and what I'm struggling with. I mean, I'm looking at the language from Ashford, which is now, a couple months old at most, right? In which Judge Gaziano literally goes out of his way to say, hey, it should be pretty easy to prove this. In our Commonwealth, we're not bound by the federal law. So it's permitted to submit a much broader class of evidence than the so-called Shepard documents. And it should not be difficult for the Commonwealth to prove that a defendant intentionally has used force.
Yeah. Well,
so, reading that, let me just finish, because you raise an interesting and an important issue, it seems to me. Reading that on its face, it suggests that you could put in what the underlying crime, what the criminal acts were, as opposed to being linked into what was said in the plea colloquy. So the question for you is, suppose that I was, in your view, foolish enough to read Ashford that way. What's the problem with reading Ashford that way? Is there some other principle of law I need to be worried about?
Yes, Your Honor, and that is to say, they've always said you have to show the legal theory or common law basis for the conviction. So it seems to me that there's a lot of language flying around which hasn't been well thought out. That's my respectfully submit. If I may I know my time's expired, but I would also just like to submit that even if you take the other approach that the Commonwealth could just put on witnesses and without reference to what the facts were at the plea colloquy, I would respectfully submit that the evidence that was adduced to trial was legally insufficient to prove, first of all, that there was ABPPO and assault with battery with a dangerous weapon. First of all, neither, as I make extensively argue in my reply brief.
Counselor, I think we're gonna have to leave it there. Time's out. Unless there's.
I would just like to leave that last thought, Your Honor, that even if you take the other approach, that the evidence was still legally insufficient, and I'm sorry I didn't get to that. So,
unless Judge Englander or Judge Singh have another question. All right. Well, thank you very much. It was very helpful, and we'll turn to Assistant District Attorney King. As you know, you are not required to be ready to discuss Ashford, though you certainly may. And if you are ready, I'm sure we would have questions about it, but that's up to you for our court order. You can go ahead.
Thank you, Your Honors. Michelle King, Assistant District Attorney for the Commonwealth. I did take your order at its face, and I'm not prepared to talk about Ashford today. I wanted to file my response after having given it the proper thought. So with that in mind, in the light most favorable to the Commonwealth, there was sufficient evidence of 3 prior predicate offenses under the ACCA such that the lower court properly found that, and this court should affirm that decision. With regard to a violent crime, if it's not one of those crimes that's enumerated under the statute, the Commonwealth has to show a violent crime, which essentially means a harmful battery, substantial physical force, capable of causing pain or injury. In this case, there was testimony from Officer McKiernan that.
What do you say to your brother's argument, counsel? He says all of that is irrelevant because we don't know what was said in the plea colloquy, and the plea colloquy is the key because that's the only thing that he was convicted of.
Well, I disagree, Your Honor. Certainly, we don't have the transcript of the plea colloquy in front of us, but the cases are clear that at this stage in Massachusetts, which is obviously, as you have pointed out, different than the federal jurisdiction, but in Massachusetts, trial court, in order to consider whether an offense qualifies as a predicate offense, can take any evidence. And what we have in this case, we don't have the language of the plea colloquy, but we know that the elements must have been set forth by the Commonwealth, or otherwise the trial judge would not have accepted such a plea.
But he could have set forth the elements that are inadequate under our case law.
Correct,
And
Your
we
Honor,
don't
but
know
that
that,
would have,
right?
that's, I'm sorry, I didn't mean to, I've got a lag and I didn't mean to cut you off. That,
No, I'm sorry. I mean, you know, I apologize for an argument that may be a little bit difficult to go through, given that we're not going to talk about Ashford, but we have a situation where without knowing what was presented to the judge, you're retrying a case that may not be what he was convicted of. And what am I missing?
I understand your point, Your Honor, but the case law is clear that when you're looking at predicate offenses and whether or not they are a violent offense, the Commonwealth isn't required to retry the case. The Commonwealth is only required to show that that predicate offense was in fact violent. In this case, you have a plea colloquy, which certainly must have set forth the elements of the crime. Why
does that make sense as a matter of policy in light of the way that the statute is written? The statute talks about being previously convicted, right? So if you come in many years later, in this instance, I'm going to say 14 years after the events, and you have a police officer come in and say, this is what happened. And you then say, okay, now we can enhance on the basis of that police officer's testimony. Aren't we missing a step, which is what was he convicted of?
Well, except, Your Honor, this SJC has said you can do exactly that when it says that you can bring forth any evidence that will show that it qualified as a predicate offense. And in this case,
yeah, but they do have that language that's impenetrable from the First Circuit case that they cite in, I think it's Eberhardt, right? It's Judge Cordy's opinion. They're saying something there. It's just almost impossible to figure out what it is. But it seems to me that it's saying something different than that you can bring in anything. And frankly, if you can bring in anything, isn't counsel right? You got a double jeopardy problem. It has to be what you convicted them of, not what you decide to try 14 years later.
Counsel, the problem I'm having with this is you must have seen in many pleas, let's say it's an assault and battery, and the defendant is going to agree that there was a unconsented to touching, and that's what the plea is based on. It still meets the elements of the offense, but the Commonwealth, their position may be, no, it was a punch in the face. without knowing what the defendant, I mean, a plea is the defendant's acknowledgement. Yes, this is what the conviction is based on. And without that, but his acknowledgement that it was simply an unconsented to touching, and the Commonwealth is saying, no, it was a punch to the face. And now, without knowing what he actually pled to, it seems like there's a fundamental fairness issue for the Commonwealth to be able to come in later and say something that might have been completely contrary to the plea agreement.
I understand your point, Justice Singh. However, I think the SJC has been clear on that. Excuse me. And if you look at 128 decisions coming out of this court, there are a number of cases where exactly what happened in this case happened in those cases. And they all followed the standards set forth in Eberhardt, and that is you can bring forth any evidence after the point to supplement or enhance what happened at the plea colloquy. Otherwise, the big problem is going to be 15 years later when a defendant decides to challenge this issue and all of those transcripts have been destroyed, there'll be absolutely no way of
the problem is the
this.
Commonwealth's problem. 15 years later, where the Commonwealth decides that they want to prove, because it is their obligation, that these things happen so that they can get an enhanced sentence, the Commonwealth needs the proof.
And that's what the Commonwealth does when they bring forth the witness to the crime.
If they go in and they have police officer X, as they did in this case, say, this is what happened, they do not prove what he agreed happened. And so you either have a risk that it's double jeopardy. They're literally coming forward with a crime that was not asserted before, or you have the risk that you would have to retry the whole case. The defendant would be allowed to take the stand or have put on his own evidence or cross-examine as to whether those events actually occurred, right? I mean, that has to be right. The latter has to be right.
I respectfully disagree, Your Honor.
You can't disagree with the latter. He's entitled to a jury trial as to what happened.
But by pleading guilty, he waived that right to the predicate offenses.
That's the Commonwealth's position. That's the Commonwealth's position, that he's not entitled to challenge it the second time around.
What's the purpose of the trial?
The ACCA?
Yes. It cannot be the Commonwealth's position, on the one hand, that because they have a jury trial, they can put in whatever evidence you can't put in under the federal statute, but on the other hand, he doesn't have a right to challenge it. Is that the Commonwealth's position?
No, Your Honor, that's not the Commonwealth's position. The Commonwealth's position is the Commonwealth is not required to retry the predicate offense. If Your Honor's position is adopted, then in every case, the Commonwealth essentially has to show and retry the predicate offense. The case law is clear, that's not required. We're not in the federal jurisdiction. In Massachusetts, that's not required. And
but
the
how does
Commonwealth can bring forth any evidence that they want to, any evidence at all, to talk about or to address the issue of a prior predicate offense. That's the case law. That's what
I don't think that's case law, counsel. I gotta say.
Judge Singh has a question.
How does the defendant, you say that they have the ability to challenge it, correct? It's a jury trial.
I'm sorry, I didn't hear your question, Your Honor.
The Commonwealth has the right to put forth that evidence. The defense has the right to challenge it.
Of course.
Are you saying there are limitations on the manner in which they may challenge it?
No, the defendant can challenge it however they want to. The defendant could testify. The defendant could call other witnesses to the event. The defendant's always entitled to bring forth their evidence to rebut the Commonwealth's evidence. That's their right.
Let me ask you a
question. The defendant didn't do so here.
Let me ask you a question.
The Commonwealth made out their case and there was no rebutted evidence.
So what happens if the colloquy, we know what the colloquy is, let's say we even have a transcript of it, and it says facts that would establish either an intentional assault and battery or an offensive assault and battery, facts that could go either way. Does that count as an armed career criminal predicate?
Well, if you have then supplemental evidence from a police officer that it was a harmful battery, then that issue goes to the trier of fact to determine. And the trier of fact is in this case, is the trial judge on the ACCA. It could be a jury if it wasn't jury waived.
What if we know the colloquy only established an offensive touching, but you have an officer who can testify that it actually was an intentional touching? Does that count as an assault, an ACC predicate?
Are you saying if it was agreed upon in
We had the
colloquy that it was only an offensive?
We have the colloquy, and for whatever reason, the colloquy only makes out an offensive touching.
And we know that for certain?
Yeah, we got the colloquy. We're looking at the colloquy, and for whatever reason, the prosecutor only mentions facts that would establish an offensive touching in that colloquy. But your officer can say, well, if the prosecutor had read the whole report, they would have heard that, in fact, he then punched me in the face 3 times. Is that a predicate or not?
I think that's a greater problem, Your Honor, because what you have in front of you potentially is, evidence that it was only an offensive touching. However, again, I would suggest that you have to look at the whole picture, and the whole picture would be, perhaps the Commonwealth only put forth evidence of the offensive touching, and then you have other evidence to rebut that. And then again, that goes to the trier of fact.
Do you agree that the 1998 conviction is for the door? That's how I read the docket sheet, that he only pled to the door counts, but I could be wrong.
No, I believe he pled to the shod foot and the door. It was the same offense, Your Honor, but only one of them could have been counted, because it was the same incident, a kicking and the door. So the trial judge said, I can only consider one of those.
Is your brother correct? There was no evidence that he had anything on his feet?
I don't know, Your Honor.
Can the door be a dangerous weapon?
Absolutely.
There's case law on that, like from car doors and stuff like that?
Well, I don't have a case to point to, Your Honor, but I'd be happy to find one for you. If there are no further questions, I'll rely on my brief.
Anyone? All right, well,
Thank you.
Thank you both. It was very helpful to the court. ADA King, you have until April 14th to file a supplemental brief responding to the Ashford issues raised in your friend's reply brief. So we will expect to see that. And thank you very much, both of you.
Thank you.
Yeah, thank you.
The case is now being recorded.
Wonderful, thank you. I'll call the third case of the day, Commonwealth versus Perard, 20P302. And before we start, I would just like to mention that Attorney Osborne had some criticism of the Mass Guide to Evidence, and that there have been changes on it online that are consistent with his criticisms of that. I just thought everyone should know that. And the print copy will have changes along the line that Attorney Osborne suggested. So with that being said, Attorney Osborne, the floor is yours.
Thank you, Your Honors. Good morning. I represent Robert Perard, and Mr. Perard raises several claims in this case, each of which has its foundation in the way this case was investigated, and the rush to judgment that Mr. Perard was the perpetrator. I'm not sure it was actually a rush to judgment. It was probably more of a myopic focus because it took so long to actually get to the point of arresting him. Within days after Ed Harding was robbed at a Shell convenience store, detectives decided that the store clerk, named Felicia President and her sister Chelsea were involved. And I'm going to refer to them as Felicia and Chelsea. I don't mean disrespect to them, but since they have the same last name, it's easier. A few weeks later, they decided that the actual robber was Mr. Perard. And that conclusion was based on only two facts, that he was a heavy-set black male and that he had some sort of a relationship to Chelsea. The problem is that they had no other evidence of his guilt. They had no identification by Mr. Harding. They had no other witnesses, eyewitnesses or otherwise. They had no clothes that matched the perpetrator in the surveillance video. They had no gun. They had no fingerprints. They had no proceeds from the robbery. They had absolutely nothing at all. So for some reason, 5 months after the robbery, they get around to questioning Felicia. And the pretext is to, or maybe it's not a pretext, but it starts with an unrelated crime. And then it turns into some intimations that child services may have to get involved in her family situation because she's a heroin user. And then they start talking about this robbery, this shell robbery. And they show her a picture of Mr. Perard. They ask her first, if she had, what's her story? And she confirms the story that she's told them in the past. And then they show her a picture of Mr. Perard, and they say they know that he's the robber. They know that she was involved and her sister was involved. And essentially they tell her the story that they want her to hear. And eventually she gets to the point where she implicates Mr. Perard and her sister. And you can see that I submitted a copy of the interview. I filed a motion to allow you to include that in the record. And I hope your honors will look at it, because it does lay out for you exactly how the incriminating evidence against Mr. Perard came to be. And it's very enlightening.
So let's assume we accept everything you just said. Which argument of error does that go to?
I think it goes to all of them, your honors. And probably this is a good point for me to actually get into it. Because every one of our claims has to do with the fact that there's really very little evidence against Mr. Perard, except the fact that they've pressured Felicia, and then in relation to Felicia, they've also pressured Chelsea to implicate Mr. Perard. And at no point from that point until Mr. Perard is convicted, does the evidence ever get any better? In fact, it gets worse, because Felicia doesn't actually testify at trial, and it's left to Chelsea to incriminate Mr. Perard, and she wasn't at the store. So let's talk about the claims. I understand your honors are probably anxious to hear that. The first claim is that the indictments should have been dismissed because of exculpatory information that was withheld from the grand jury. And that has to do with, I'm sure your honors are aware of this because you've read the materials. Yeah. That claim has to do with the fact that Mr. Harding, the victim in this case, told the police within hours of the robbery and his assault that a woman named Shelley Viveros, another store clerk who was not
present. Let's assume Shelley was involved. Let's assume Shelley was involved. Yes. Everyone agrees she's not the person who committed the robbery itself.
Correct.
How does that, I mean, the standard for grand jury is, and I don't have the language right in front of me, but it's basically that the omission has to either be deliberate, or it has to severely undermine the process itself. How does Shelley severely undermine a grand jury indictment of Perard?
Sure. So the case is Odell, Commonwealth versus Odell. I'm sure your honors are familiar with it. And the standard is whether the information that was withheld significantly undermined the credibility of an important witness. Now, I don't think there could be any doubt here that Felicia President was an important witness. She was the only witness who testified to the grand jury who actually incriminated Mr. Perard. The only other witness was Detective Souza.
So it undermines her testimony because she left Shelley out of her story.
Yes, her story is inconsistent. Not just does she leave Shelley out, but it's not actually the same kind of story. Because if you accept Mr. Harding's statements to the police, he's basically suggesting that there is some sort of retaliatory motive to this robbery or this attack. he says that the robber said to him after the attack was over, he said, "This is for Shelley." Now, if this is just a run-of-the-mill robbery, an opportunistic kind of crime, which is the way that Felicia described it to the grand jury, and I won't get into her testimony because it's grand jury testimony, but you have her testimony in the impounded appendix. If she, her story is that it was just an opportunistic thing. Mr. Perard was looking for the money that he learned that Mr. Harding had on him. There's a completely different motive here, according to the evidence that Mr. Harding presented. The evidence, the motive seems to be that there's some sort of there's a real or perceived grievance that Shelley has against Mr. Harding. And that's why the perpetrator would say something like, "This is for Shelley." And by the way, there was no evidence at the grand jury. There's no evidence at trial that Mr. Perard had any knowledge of who Shelley was. There's no explanation of that. So that's how it's exculpatory. And by the way, the other thing.
But Counselor, the grand jury's job isn't to determine whether Mr. Perard committed the crime. It's to determine whether there's probable cause.
Correct.
To indict him.
Correct.
Even if it hurts Felicia's credibility that she doesn't explain Shelley's involvement in this, what's your argument that it hurts it so much that a jury can't believe her enough to find probable cause?
Sure, it's because there's no other evidence. This entire grand jury case rested on whether or not you believed that Shelley was that Felicia is telling the story as it happened, and the grand jury had reasons to feel that her credibility was tenuous. She lied to the police for months. They had the interview where they see that detectives are pressuring her to point the finger at Mr. Perard, and they know that she's testifying pursuant to a cooperation agreement. So there are a host of factors that would make them have some questions, to be a little suspect about whether she's telling them the whole truth. And then if you add onto that, you layer onto that the fact that this information from the victim himself, fresh information.
But the information from the victim, if we step back,
Sure.
It's not really information. Right. This is just, he doesn't know what just happened to him. And that's the first thing that comes to mind. So it's a little bit different to say that it's sort of evidence. Yeah. It was the first thing that came to his mind, maybe backed up by nothing except, his impressions.
Sure, Your Honor, but there is a statement that he attributes to the perpetrator. He says the statement the perpetrator made to him.
All that is evidence that the perpetrator said it. It's nothing beyond that.
Right. But it's evidence of a motive for the crime, and it's also was not mentioned by Felicia. That was not her story. The story that she told did not mention that statement that she had to have heard, because she heard everything else.
There was no evidence that Felicia heard that.
There was none. That's correct. There was no evidence of that.
Right, but you're speculating that she heard it and therefore she left it out. There's no evidence that she heard it. Wow. We're going to get through a lot of this without talking about a couple of the other issues that are interesting to me. And the one that I would like to focus on for a moment is the judge's exclusion of the ability to cross-examine Chelsea regarding Felicia's deal.
That's fine, Your
Honor. And you make an argument that of course, this was important, that Chelsea knew about Felicia's deal before she entered into her deal, and that should have been able to be brought out before the jury. Was that argument made to the judge below?
It was not clearly made. It was not. I appreciate the position that trial lawyers are in, and they often have. They don't always set up claims as nicely as you would like, but we know this. We know that the trial counsel filed a motion to allow him to explore widely cooperation agreements, And we also know, interestingly enough, that the prosecutor at the same time filed a motion specifically to exclude any mention of Felicia's cooperation agreement, because at that point they knew that Felicia was not going to testify. So those two things combined, I think, put the judge on notice that there's an issue here about whether or not how
Was the sole basis for exclusion the argument the Commonwealth made that was basically Felicia's not testifying, so it's irrelevant?
I'm sorry, could you say that again, Your Honor?
Was the sole basis for exclusion the prosecutor's argument that went, Felicia's not testifying, so it's irrelevant?
That's correct. That my reading of it is that was the basis for the judge's decision, that she was not testifying. But Mr. Hanley, the trial counsel for Mr. Perard, wanted to explore very broadly all these cooperation agreements. He filed a motion to allow him to do that. And what's important to note is that this information about Chelsea's knowledge of her sister's cooperation agreement came out because Mr. Hanley actually elicited that during her.
Yeah, he voir dired her after this was taken up the first time. And then, but after the voir dire, he's stuck on this notion that he wants to show that Felicia was involved in the other robbery, and he doesn't really make the argument, it seems to me, that you're making here, and I'm struggling with the significance of that.
Well, I agree with Your Honor that in an ideal world he would have made that more clear to the judge after that information came to light. But I think it's very clear that he wanted to broadly cross-examine her on cooperation agreements. This was the whole case for him. It was to prove her. Well, it was half the case. Half the case was to prove that there was an inadequate investigation. The other half of the case was to undermine her credibility. And since he did elicit that during her voir dire, I think that was.
Did Chelsea's cooperation agreement say that she did not have to implicate her sister?
Yeah, they did. They went both ways. Felicia's agreement, which we included in our supplemental appendix, it wasn't in the initial appendix, says the same thing. It says that she doesn't have to implicate her sister, and Chelsea didn't have to implicate Felicia. So
what does that mean? I've never seen anything like it before. I'm sure that Judge Ditkoff and Judge Singh have, but I mean, if you're asked a direct question, you have to answer it truthfully.
I agree. It's strange. I get the impression that maybe it was drafted on the fly, maybe it was inserted at the request of counsel, and then it was just made.
You don't think that means she didn't have to testify in a trial of her sister?
No, I think she did have to. I don't know. I think we can speculate about how it would have played out. It would have been very awkward because this trial was going ahead, and Felicia was supposed to be the star witness. Had her sister not cooperated with the Commonwealth, I think that there was no issue about a severance. I think they would have been in a joint. She would have been in a joint trial with Mr. Perard. It's hard to imagine how you could have insulated Chelsea from her sister's testimony that would have implicated Mr.
You
Perard.
have to sever it because she can't be forced to testify in a trial where her sister is the defendant?
I'm sorry, say that again, Your?
Wouldn't you have to sever it because she can't be forced to testify in a trial where her sister is the defendant?
I don't know. You're raising good questions, which I think I don't have a good answer to. Maybe the Commonwealth has a better insight into how this was drafted. I don't have much insight into it or how they expected it would have played out. I suppose you could have somehow excised her, redacted, or excised her statements instructed her not to have testified to certain things. It's hard to imagine, but it's one of the peculiarities of this case that you have these two cooperating.
All right. Well, I think we'll have to leave it at that unless my colleagues have any more questions.
Yeah, I just want to emphasize that this is because the Commonwealth raised the question.
No, I think we'll have to leave it there.
You want to leave it there? Okay, that's fine.
Expired. So Assistant District Attorney Kidd, you have the floor.
Yes, good morning, Justices. Again, so my name is Rob Kidd. I represent the Bristol County DA's office. Starting with issue number one, which is the fact that this information regarding Shelley was not presented to the grand jury. I will say that the trial prosecutor did tell the judge that in ideal grand jury practice, it probably should have been mentioned. But the question is whether or not the process was distorted to the extent that the jury indicted this person based on distorted evidence, and the prosecutor intentionally or recklessly presented this evidence. Regarding the latter thing, whether the prosecutor intentionally or recklessly presented this evidence, you got to look at all the information that she had, and she was not the trial prosecutor, by the way. The evidence that she had at her disposal were these reports, and these reports to her show that there was a black male, stocky black male entering this store. He was on surveillance video. He was making eye contact with the clerk. She had information about Shelley in these reports, but basically the information that she had about Shelley was that police pursued that. They spoke with Shelley. They spoke with her mother and learned that Shelley had been out of state during the time, and they interviewed Shelley as well. So based on that, based on the fact that she was not dealing at the time, she was not dealing with Shelley's indictment. She was dealing with the defendant's indictment, who was a black male. I don't think that you can say that her failure to present this to the grand jury was done for the intent of getting an indictment. It was not. She was obviously a line prosecutor doing her duty, presenting the case. Her job in presenting this case was to present a case with respect to this defendant, and she actually did that.
Her job's more than that, to do it fairly and not to leave out critical information. There's a piece of your brief where you say something like that, and I read it and I wrote in the margin, no, her job is broader than that, right, counsel? She certainly, in the context of trying to get an indictment, should not leave out important information.
No,
and this was important information. This is the guy says, this person said to me, this is for Shelley. That should have been before the grand jury, right?
And I think what we said to the judge at the time was that it should have been presented. But the question is whether or not it was omitted recklessly for the purpose of obtaining an indictment. And I guess what I was just trying to convey was she was looking at the case with the perspective of presenting it with respect to this defendant, and it very well could have overlooked at that particular evidence and should have presented it, and she didn't. And
so there's nothing. What you're saying is there's nothing to suggest that leaving out the Shelley information would somehow improve the chances of the indictment.
No, exactly. Yes. I think that first of all, there's no evidence that the witness who testified before the grand jury was aware of this Shelley or this statement. That's the defendant's theory. The defendant's theory is that the witness who testified, Felicia, knew about this Shelley and left her out of her testimony to protect Shelley. We don't know that. We know that she didn't testify about a Shelley. We don't know that she even knew that Shelley was involved. If Shelley was involved, it's possible that she was some sort of third party that was brought into this supposed conspiracy, and it was the witness who testified didn't know about it. So I think it's a tenuous argument to make, with all due respect to counsel, and I don't think in the end it caused the jury to indict this defendant.
Okay, let's switch then to another argument. Shouldn't defense counsel have been allowed to cross-examine Chelsea regarding Felicia's cooperation agreement under the circumstances?
I'm going to be honest with you. I've been reading the defendant's brief, and I know I wrote the brief responding to it. I'm still struggling with how that has a relevance to the jury with respect to the fact that one sister knew about the other sister's cooperation agreement when she testified. The sister who testified, Chelsea, had her, as I said in my brief, she has her own reasons for entering this prosecution agreement. She is as much as a suspect as her sister. She's implicated in this robbery. She has an interest in protecting herself by entering this prosecution agreement. The fact that she knows about her sister's agreement, what does that mean? She's hoping that she can.
How about, I mean, this is what I understand your brother to be saying, and I confess that I'm not struggling with it. He's saying that this was a conspiracy to commit an armed robbery, that there were 3 people involved, at least, Felicia, Chelsea, and your client. I'm sorry, his client, or someone. He's actually saying Felicia, Chelsea, and someone else. He's saying that what Chelsea found out was that, and that's a pretty serious crime, conspiracy to commit an armed robbery. Chelsea found out Felicia was off the hook because she'd entered into a cooperation agreement and she'd fingered Perard. So now Chelsea has to figure out what to do. So Chelsea says, well, I think I'm going to take the same route that my sister did. I'm going to finger the same guy. I'm going to provide evidence in that regard. And now I get off the hook. And if that's what defense counsel wanted to present as a defense, there really wasn't a whole lot of other evidence that was in the way of presenting that as a defense. And he should have been able to cross-examine Chelsea about the fact that she knew about what her sister had done to get off the hook. That's his argument. What's wrong with that? Why? That seems to me to be a very logical argument.
I am understanding what Your Honor is saying now. There was a voir dire hearing, as the court knows, and counsel did have a chance to cross-examine Chelsea about all of her testimony. You just expressed an interesting theory as to why this would be relevant. Counsel there's no evidence in the record to support that this witness, the sister, she decided to testify against this person because she heard about her sister's agreement. It's all it is timing. She learns about it afterwards. I say it's speculative. I just, as I said, she has her own reasons to cooperate. She's a witness.
But you know, the jury's presented with this evidence. Her sister is all over the case, right? Her sister's on the. She's a big part of the case, of the prosecution's case. She's on the video, nodding at the perpetrator 9 minutes before it happens. So it's not a crazy thing to think that the jury is going to have to decide what Felicia was doing and what Chelsea was doing in the particular context of the evidence, is it?
I don't think it's enough to warrant the action that's in the brief. I mean, I don't think that. I still see it as.
But why is the Commonwealth trying to exclude that evidence under the circumstances? The Commonwealth doesn't want the jury to hear about a person who's at the center of the case and what her cooperation agreement is. And it seems to me that strikes me as really being very aggressive. Okay, well, they've let her. We lost our witness.
I'm sorry, I interrupted. Go ahead, Your Honor.
No, that's all right. I mean, she doesn't show up for trial, and yet it's clear that she's an empty chair that nobody's making up. She's literally on the video, nodding at the perpetrator. Why is the Commonwealth trying to keep out her cooperation agreement?
Well, I think that maybe in fairness, the Commonwealth. I think it would also be fair if we were able to present her and we were in an unfortunate situation where we couldn't put that witness on. Like you said, now we have the empty chair. We can't get her up there to explain her version.
Problem, not the defendant's problem.
I don't know if I can answer that question any more than I have, Your Honor.
Could you address the third party culprit issue?
Yeah, again, that's yeah, just give you a second, Your Honor. Yes, excuse me.
Maybe I can just direct you a little bit. The defense was allowed to do certain things and not others in terms of the third party culprit theory. So are you suggesting that they were that basically that they were allowed to present the theory fully?
Not all of the theory, no, but I think that, if you just give me 1 second, I'm just going to turn to my brief so that I can. So I think the question, the broad question is whether the judge abused his discretion in determining, whether or not to admit this testimony. And the testimony, the judge found that the pizza robbery, first of all, so we have two pieces of evidence, right? We have this pizza robbery that had occurred 3 years ago in a separate town in Taunton, 3 years before the offense. And then we have these Cumberland Farm records showing that these persons were employed at Cumberland Farms and may have taken some stuff from stores. None of these incidents were ever charged against these persons. With respect to the pizza case, the judge found it was too remote in time under the standard. She also found that because nobody was charged and because the persons involved were described as two black males. One of them, Almeida, is a white Caucasian male. It just didn't match. The evidence just didn't match. It was too speculative. It was too remote in time, and it would have caused the jury confusion to admit this evidence. That being said, I think that the defendant was allowed to present some evidence regarding this Travis Bogarty. He was an African-American male of a similar height and weight as the other person, and he had posted bail for one of the defendants, I believe. So there was some evidence presented. I don't think that was an unfair decision on the judge's part. With that, I think I have 3 minutes left, but I'm not a big user of time. So
Any more questions?
I tend to get myself in trouble. Go ahead.
Any more questions? Looks like
I guess I kind of do, if it's okay. I apologize. I want to stay with the third of the four issues that were raised, which is this issue of Felicia's cooperation agreement. Just assume with me for a moment that the judge was in error in denying the opportunity to cross-examine about the cooperation agreement. Is there an argument out there that that was not prejudicial anyway? And what would the argument be?
Yeah, I mean, I think that the jury was presented with evidence that the crime occurred. They had evidence, they had video evidence of the person who committed the crime. They had evidence that Felicia was involved with the crime. I guess you would have to say that the jury would have thought that they would have, in order for it not to be prejudicial, or for it to be prejudicial, you would have to conclude that the jury would have completely thrown out Felicia's testimony had that cooperation stuff. Chelsea's. And I don't think that is the case. I don't think that is the case. I think that Chelsea was credible in the sense that, she admitted to the police that she had lied. She came forward. She came forward in the case, and they could judge her testimony as it was, and I don't think that it rose to the extent where the jury would have disbelieved the entire theory of the case. But
Okay, thank you.
Okay.
Well, thank you very much. Thank you both.
Thank you, Your Honor.
Really helpful to the court. Great briefs and great arguments. Thank you.
Thank you.
The case is now being recorded.
Thank you. I'll call the fourth case today, Ralph versus Civil Service Commission, number 20P977. Mr. Ralph, you have the floor.
Good morning, Justices. My name is Thomas Ralph. I'm the appellant. And this issue is one of first impression relative to the language in Chapter 31, Section 59, Paragraph 5, specifically a member of a regular police force who has served as such. This court should find that all members of a regular police force are eligible for preference points. The Civil Service Commission's interpretation creates an unjust system of awarding points among equivalent civil service and non-civil service members. And it is the court's determination to determine legislative intent. Thus, the lower court committed an error of law in affirming the commission's decision, specifically when it ruled that regular meant only a regular police officer and a regular civil service force. Regardless of what the court rules today, the issue will be clarified and it will be corrected, and an unjust system of awarding credit to civil service part-time officers and not to non-civil service part-time officers will be corrected and will give guidance to the Civil Service Commission.
Do you agree that if we find, this is of course a huge if, the auxiliary and special police officer time doesn't count, that the time at the UMass Lowell campus police doesn't really matter? It doesn't get us there either way?
UMass at the time that this took place did not get us there. That's correct.
And you're at 25 now, right?
That is correct, Your Honor.
Undisputably, so, okay.
No matter how you rule it, it's undisputed, yes.
All right.
What I will tell you, Your Honor, is that when this took place, the form that Human Resource Division utilizes for this credit asks for your name, your department, the dates that you were there, and the position that you held. It does not ask for duties that were performed, and the Civil Service Commission went into depth into what duties a special police officer performed, what duties an auxiliary officer performed, what duties the UMass police formed. And the statute just says a member of a regular police force. And I would suggest that you cannot, a special police officer or an auxiliary officer cannot exist without being a member of a regular police force.
Why do you say that? That is not intuitive to this judge. Why do you say that someone who's an auxiliary police officer is a member of a regular police force?
Because when they're called to work for the department, they assume all of the rights, responsibilities, and privileges of a regular police officer, Your Honor.
But the evidence is to the contrary, that the auxiliary police did not have all the rights, duties, and responsibilities of a regular police officer. That they did traffic work and detail work, and they were volunteers. So why? It seems to me that that the word member is an important word here, and I'm not sure that either brief really addressed member. Why are you a member of a regular police force when you're an auxiliary police officer?
Because you're working for the department that you are assigned to. So if you work for Webster or Dedham or Medfield or Dover, you work for them, whether you're working as a volunteer. If you look at Chapter 40, Section 4J, it describes employee as a volunteer as well, paid or unpaid.
That's the word employee, not the word member of a police force. We're working with the word member of a regular police force. Where do I get that definition from?
Well, that's the reason why I'm here before you today, because it is not described or explained anywhere in the general laws and the statutes.
That's not true. It's a member is a defined term, for example, in Chapter 31, and it wouldn't apply here. But I'm not sure that I want to go grab the definition of member in Chapter 31. But I'm telling you that the word is defined.
I believe they define permanent member, but I'm not sure that they define just the word member, Your Honor, but I may be mistaken.
What do you make of Section 11C of the Civil Defense Act, which says that an auxiliary police officer can only do tasks that cannot be adequately handled by the regular police force? Doesn't that suggest that auxiliary and regular police force are different things?
Well, they supplement the regular police force, and they have all the rights and responsibilities, and they're trained and utilized. So when I was in Dedham and I was doing 20 hours per week, we're training, we're working, we're going out and doing various patrol type duties of town properties to assist and supplement the regular police force.
Sir, you keep using the term, we have all the same rights and responsibilities.
Yes, Your Honor.
So is it your contention that references in the record to limitations on responsibility are incorrect?
Yes, Your Honor. If you look at the Chapter 635 of the Acts of 1950, the Civil Defense Act, it states that the auxiliary police officers will have all the rights, responsibilities, and privileges of a regular police officer.
So evidence in the record with respect to, well, there's only certain responsibilities that were in fact given to auxiliary officers. You're saying that's sort of irrelevant, given the powers.
Yes, Your Honor. I also believe that had the commission held a hearing on this and not dismissed it on the motion dismissed by HRD, this would have been delved into at that time as to what responsibilities and duties were actually performed. If you look at the commission's decision, it states that they believe that some auxiliary departments may qualify for this credit, but that HRD should not be burdened with determining whether or not each and every auxiliary department qualifies for the credit. But that's actually HRD's job, is to determine that or make a better form or clarify the language as to who is eligible and who is not.
What's an irregular police force? You have a regular police force. What's the non-regular police force?
What's a non-regular police force? So far, the cases that have come up at this point, specifically DeFrancesco versus Civil Service Commission, in which Judge Kern of Middlesex Superior Court affirmed the Civil Service Commission's decision, is that if no member of the department could be a regular police officer, that they only got their authority as special state police officers from the colonel of the state police, then that was a special police force and not a regular police force. The only case that I have found that I believe would have bearing on this is Maloney versus Milford from 1925. It's 253 Mass 400, in which the SJC said that the under Chapter 31, Milford Police Department was regular in that it was had regular members, it had specific duties, it was organized under town bylaws, had annual appropriations. That was what they deemed regular as.
And that's why you didn't claim the Suffolk University police force time?
That is correct, Your Honor.
Mr. Ralph, or counsel, I guess I could call you either. Is it your position that part-time work counts for the equally with full-time work? In other words, if you are a part-time, I'm going to use the word member, but I without prejudice of an auxiliary police force, for example, Dedham, that each year counts as if each year of being a part-time member counts as if it were a full year? What's the basis for that? Why would that make sense? If what we're looking for is experience and you're working 8 hours a week, why would that be the equivalent of a full-time employee?
The Civil Service Commission in 2005 in Neville versus the town of Wilmington determined that part-time credit for a civil service officer was creditable, and they gave them month for month, regardless of how much they work or how little they work. And so that's where I say that it's an unfair system at the moment, in that civil service is
That's a
credited.
decision of the Civil Service Commission, never been said by any court, I take it.
That is correct, Your Honor. But civil service has created this unfair system in that they are crediting part-time civil service employees. When I took these promotional exams, I had several months of civil service part-time experience. They credited that experience without question, month for month, no question asked, didn't ask my duties, didn't ask anything else. Yet when we get into special and auxiliary, they delve into regular police duties, regular police force, and they're not treating civil service officers the same as they're treating, they're not treating non-civil service officers the same as they are treating civil
And
service
why
officers.
is that irrational? Because it
Because the
seems to me
stat-
your position has to be that that's irrational.
It is irrational, Your Honor. The Civil Service Commission specifically is set up to prevent bias, and in this instance, they're creating bias by only awarding preference to civil service officers.
Telling me it's biased doesn't help me at all. What evidence in the record would allow me to determine that it is irrational to distinguish between someone who's in a civil service position as opposed to someone who's in a non-civil service position operating in some way associated with the police force?
The Civil Service Commission, again, unfortunately, there's no, as you know, no case law on this, but the Civil Service Commission has stated that they will credit equal positions in non-civil service towns, but they're not. They state that, and they're not doing that. The jobs are the same. A special police officer is the equivalent of an intermittent officer. A special police officer in a non-civil service town is
How
the
is that
equivalent.
evidence in the record? How could this court decide what you just said is accurate?
So in the record, you'll see that special police officers are appointed pursuant to Chapter 4196 in the record, and they have all of the authority of a police officer. Prior criminal cases, Commonwealth versus Rarick, Commonwealth versus Wren, Commonwealth versus Andrews, all discuss police officers making arrests and, and doing various performance of their duties as special police officers in non-civil service towns. And there's never been any question on a criminal side that they have police authority and they have police officers.
So there's such a thing as a non-civil service town. There are towns in the Commonwealth that have no civil service at all and have a police force?
Yes, Your Honor. Webster Police just left civil service this year. They're no longer a civil service community.
And
they're now
under those
non-civil service.
circumstances, the concept of an intermittent police officer is not used anymore. Now you would use the concept of a special police officer. Is that what you're telling me?
So Webster actually calls them sub-patrolmen. They don't call them intermittents or specials at the moment. And their auxiliary force is in Webster is referred to as a reserve force, although it's not created pursuant to the law. And this is where this issue of just having a title plays into effect with the Civil Service Commission. If I was in Webster as an auxiliary and they filled out the form and said I was a reserve, the commission would have granted that time without question, never asking the duties. There's a disparity in the system.
Sounds like it's a problem with terminology.
I believe it is, Your Honor. So if you look at the Civil Service Commission, they interchange full-time member, full-time duties, regular police duties, regular police force, regular police officer, permanent, tenured. They interchange all of these words into the statute, and it's clearly not their place to add words to the statute. It's their job, their job was to interpret it. I don't believe they did that correctly, which is why I'm here today, and I'm asking for the appeals court to interpret that phrase and that statute so that it's clear for everybody else in the future that are seeking these preference points.
Right.
Sorry. Yes, sir.
Is that all right? It seemed like you were winding down.
I am.
You don't have to take all your time.
I would just like to finish up with saying that in Jones versus Wayland, which is in the brief, the SJC and the appeals court both stated that any terminology that referenced police officer without a limiting term in front apply to all officers. And I would say that in Chapter 3159, there are limiting terms earlier on up in the paragraphs, and there is not when it comes down to a member in paragraph 5. I would ask you to find that the Civil Service Commission is arbitrary and capricious and an interpretation that is in violation of the law, specifically relative to the preference points as it applies to members of a regular police force. And I respectfully request that this court find in favor of me and rule that the statute's 10 for purposes of promotional preference points applies to all members. Thank you.
Wonderful. Thank you very much. It's very helpful. I assume there's no more questions. All right, then Assistant Attorney General Martland, the floor is yours.
Good morning, Your Honors. Douglas Martland, Assistant Attorney General for the Commission and the Division. Mr. Ralph failed to establish this claim for civil service preferences under 2 statutory preferences, and the Commission properly dismissed his appeal. Addressing the 25-year promotional preference first, Mr. Ralph did not establish that he was a member of a regular police force who had served as such for 25 years. The statute's plain language expressly requires a police officer to have served as such in the positions like auxiliary police officer, special police officer, and campus police officer simply are not service in the position equivalent to that of a member of a regular police force.
So are there Civil Service Commission decisions that say an intermittent police officer is a member of a regular police force?
Your Honor, to answer your question, I think we need to back up and look at the Section 59 as a whole. That section concerns the eligibility to sit and take a promotional exam for the next highest rank. The statute specifically requires in paragraph 3 that those eligible as a general matter, assuming that there are enough individuals that meet this criteria, are full-time permanent members of the regular police force. So as you would think of it in a civil service system, a civil service town, the everyday members of the police force in the rank below the rank that they're applying. If there are not enough eligible candidates, that's when the reserve and the intermittent officers may be eligible in certain circumstances. We then need to take the statutory preference in Section 59 for the 25-year promotional preference in the context of the statute as a whole, and read the phrase there, served as such, within the context of who is eligible in the first instance and what the legislature intended that phrase to mean.
So your predecessor said in a pleading that Neville versus Town of Wilmington says that temporary and permanent intermittent experience for municipal police force counts towards the 25-year computation. I mean, that's in the record, the administrative record at 26, signed by Labor Counsel, Michael Downey. So isn't the answer to Justice Engler's question yes?
Yes.
The intermediate counts? So what's confusing me here is the Civil Service Commission here suddenly pulls out full-time sworn member of a regular police force, even though the statute talks about, in paragraph 3, full-time members of the regular force. So why does it say full-time members of the regular force if to be a member of the regular force means full-time?
Because again, Your Honor, that's what the statute requires to sit for the exam in the first instance, unless there are not enough eligible individuals.
Well, you have to be full-time to sit for the exam. That doesn't mean that only your full-time time counts for the 25-year bonus.
That is correct, Your Honor. The commission and the division have not taken perhaps as stringent an approach to the statutory language as it could be interpreted to require. As Attorney Ralph mentioned in his argument, the commission has also interpreted that where you work as a regular police officer in a non-civil service community, that can count for your time in accruing the total of the 25 years. You just can't be in that position when you're seeking to take the exam because you
explain non-civil service community briefly. I know we don't have time to educate me on all the things I should know, but is that something you can opt out of? You can just say, I'm not going to be subject to the mass civil service laws?
That's my understanding, Your Honor, that the communities have a choice regarding the matter.
And once they opt out of it, they're not subject to any of the civil service laws, including how you advance police officers?
That's correct. And what the commission has determined to make to be able to interchange between the two systems for promotions, that some of that past service can count. And that's why
Okay, and you keep, I'm sorry to interrupt, but I don't want to sort of take over the conversation here in something that my brother and sister may not be too interested in, but there's a reference to the statute as a whole only talking about the ability to sit for the next higher position within your particular force. And I mean, as I understand it, Mr. Ralph wants to go, into other police forces, and I had always assumed you would have the ability to take your experience from one police force over to another. So how do I harmonize those two problems? You follow my question?
I do follow your question. You're asking as regards a separate community, if you were applying for that.
Yeah, suppose I want to go work now in, I think maybe it was Methuen or somewhere that Mr. Ralph wanted to go work in. Am I precluded, or the statute we're talking about doesn't even apply to me? I don't get this.
I'm not sure of the exact specifics, Your Honor. Certainly you would have to be a full-time member within that to sit for the exam in the first place. And I'm happy to provide a 16L type letter to the court regarding your specific question.
It doesn't make any sense to me in light of watching the whole Boston chief of police thing unfold, where if we were going under the statute you're describing, you could only take people from inside the Boston police force, whereas I know that that's not what they do. So I'm struggling with the statutory overlay here, and I apologize for taking your time on it.
Right. And again, Your Honor, this is just for a promotional preference to credit police officers who have served as such as a member of a regular police force for 25 years, to give a promotional credit equivalent to that of a veteran's preference that we give under the statute to those officers with long-standing service to their community. Coming back to both the definition of regular and also, Your Honor, your comment regarding the definition of member, the commission here appropriately identified several factors that are relevant to that definition. They're not preclusive necessarily, but they're relevant to the definition, and they were all considered here, right? The first one was whether the position is full-time or part-time. The second one is whether the position is paid or volunteer. The third are the relative duties of the position. So comparing the duties of a member of a regular police force, which includes the ability to arrest, all sorts of traffic duties, and very broad duties, compared to the duties here of the specific positions that Mr. Ralph is relying on, which are limited primarily to just traffic duties, at least according to the findings of fact by the commission, which aren't challenged by Attorney Ralph on appeal. And then the fourth factor is whether or not the particular position that you're seeking to rely on was part of the civil service system. And that is particularly relevant because there are, in the application process and in the exam process, there are specific duties listed for the provision, so that the commission could review those and understand, and also the division could review those and understand what the specific duties of the provision or position were.
I mean, the problem I have with those factors is they're all problematic. The commission includes part-time if it's for a municipal police force. The duties don't seem very important because there are police officers whose only thing they get to do because they pissed off the commissioner is sit in the evidence room and take evidence or fill out time slips. And as you explained, whether or not you're part of the Civil Service Commission isn't a problem, because if it's a non-civil service town, the time counts. So we have all these factors that don't seem to be controlling. So what do we make of that?
What we have here, Your Honor, is a situation where the commission has reached a determination of a statute that doesn't have a defined term in it. Certainly, I understand the court's questions that it's seeking to understand those meanings. And this is exactly why we defer to the commission's reasonable interpretation of the statute.
But so you're right, as far as it goes. But if we look, Judge Ditkoff has just identified, if you look at their decisions, and the decisions point in all different directions, we're no longer deferring to a reasonable interpretation. We're deferring to an unreasonable interpretation. I mean, the rules have to make sense as a cohesive whole, don't they?
Yes, Your Honor. And I don't think that the commission's decisions here point in different directions. What is very clear from the commission's decisions is that the specific positions that Mr. Ralph is relying on to qualify for this preference don't meet the definition, don't arise to the level of being a member of a regular police force. And that type of decision is exactly what we've entrusted to the commission, to adjudicate these facts, to make a determination on them, and to compare them to determine whether the duties rise to the level of being a member of a regular police force.
So that's an answer that says, if you take the specific facts, it's a rational decision. But if we were to write it just to those narrow facts, it seems to me, and maybe I'm misunderstanding, that someone could say, well, okay, except the identical set of duties and relationship to a police force would get you credit if you happen to be in town X as opposed to town Y. And if that's the case, then don't we have to explain something better than just say, well, it's whatever town you were in?
I don't think that's quite the answer, Your Honor. I would certainly agree with you that this particular decision from the commission is very fact-bound. And again, those facts are not challenged here on appeal. And from those facts, we can clearly determine, again, they're unchallenged, the status of the particular provisions or the particular positions that Attorney Ralph was relying on here don't arise to the level of being a member of a regular police force, right? His positions were primarily all volunteer. They were non-civil service positions, and the duties of those particular positions that he's relying on were all limited to traffic enforcement. And that's enough on these particular facts and for this particular case to reach the conclusion that he's not entitled to the statutory preference.
So you'd think an auxiliary police officer would count if he was investigating crimes, arresting people?
Again, Your Honor, I think it would ultimately be somewhat dependent on the facts there, but there are still the other factors that I mentioned, that the auxiliary police officer is a part-time officer, a volunteer officer, that the duties he or she may be exceeding them or not. That would come down to facts.
Well, here's your problem, that if I plug in the factors you gave me, if you're a campus police officer, you could often be full-time. He was paid for sure. Your duties would include investigating crimes on campus, and you'd have the full rights to do that. I don't know whether you're part of the Civil Service Commission, the UMass system or not, but it seems like if I apply those factors, I don't know how both the UMass and the Suffolk University campus police time don't count.
Well, coming back to your UMass Lowell example, and Suffolk is a private institution, Your Honor, but UMass Lowell, the commission is very careful to say in its decision that for current members of the UMass Lowell police force, the decision is a close call for all the reasons that you just explained. But what the commission did is look at the statute and look at the campus police officer's authority at the time that Attorney Ralph was serving there.
Right,
and
the only change in the authority is the deletion of a comma. That's the only thing that happened in the authority section in the amendment, the recent amendment. They took out a comma. It's still the same thing, that throughout university property shall have the powers of police officers, except the service of civil process. That was the old statute.
But respectfully, and I believe we described this in footnote 9 of our brief, Your Honor, the authority back then, if you look up ahead, or I guess behind technically in the statute, the authority there is explained that the position was limited to traffic enforcement duty. right? It did not.
I mean, that's just false, because the statute said, in the enforcement of said rules and regulations, that's traffic, and throughout university properties shall have the powers of police officers. So they could, on the university property, they had full police powers. It was only off campus that they only had traffic powers. I mean, that's the statute, and it's the same statute as now as was then on that section. So I don't understand that.
Again, Your Honor, the commission here relied on the phrase enforcement of said rules, right, which it construed as limited to the traffic use.
All right. I mean, if their decision was based on a clearly erroneous reading of the statute, then we don't owe deference to it, correct?
No, that's certainly correct, Your Honor. And I think you could also come back to Mr. Ralph's earlier concession that ultimately the court's determination just on this particular issue regarding campus police officers does not move the needle in either way, absent a determination in his favor on the other two.
Can we, if my colleagues will allow me one more question, Suffolk. So you dismiss Suffolk by saying it's a private institution. I know from other cases that I've worked on that campus police of private institutions are treated as having the same police, or treated as having police powers that in many ways are equivalent to municipal police powers, powers of arrest, for example. Are you saying that it's the that the CSE has a sort of a blanket rule that if you're private, it doesn't count?
No, Your Honor. I was just attempting to distinguish Justice Ditkoff's question. I think the more important point is that that particular position is not the subject to the appeal. There are three positions here that are subject of the appeal: the auxiliary police officer for Dedham, the municipal, or the special.
Right, I got it. Did I misunderstand that there was a change in 2014 to a statute associated with UMass law, with the UMass police officers that in some way seemed to broaden the responsibility of the officers? I thought that was essentially uncontested. Now I'm not so sure anymore. That's certainly the commission's position in this instance. Justice Ditkoff is questioning that, as I understand his question. Okay. But we addressed this in footnote 9 of our brief. I remember the footnote. Okay.
Well, thank you. This is a really interesting case, and we're glad to have it. And the briefing and the argument was very helpful to us. Thank you very much. We are going to take a 15-minute break now, and we'll be back around.
The case is now being recorded.
Good afternoon. We're back after our break. We've got 2 more cases. We'll get right to it. I'll call the 5th case, Department of Children and Families versus Mother, number 20P974. I'll remind you all that I'm sure you don't need the reminder, but this is an impounded case, and we won't be referring to any of the names of the family members. We'll instead call them mother, child, etc. And with that, Attorney Penta, you have the floor.
Thank you, Justice Ditkoff, and good afternoon. May it please the court, I am Michael Penta, and I represent the appellant mother, who's requesting that this court vacate the judgment and decree terminating her parental rights and remand for a new trial. Although the judge relied on several factors in finding mother unfit, she relied most heavily on her concerns with mother's substance use to terminate her parental rights. And we know this was the judge's primary focus because she expressly says so. In her footnote 3 in her findings, the judge states, had mother struggles with substance abuse not been so long-standing, or if mother could have shown more insight, the court would have considered maintaining the legal relationship as suggested by child's counsel. In her case summary, this is in the record at 139 for volume 1, she acknowledged that while some of the other factors in her decisions by themselves would not support a termination decree, they are symptomatic of mother's struggles with sobriety. And while I argue in my brief the trial counsel failed to do many things basic to the function of a lawyer, there's really only one failure that this panel should focus on. And is it a failure that any newly minted lawyer would know to do? That is to interview and call the most important witness on the most important issue. Mother's primary care physician, substance abuse counselor, and pseudo mental health provider, Dr. Mueller. And trial counsel should have known that Dr. Mueller was the most important witness because the judge telegraphed her concerns with mother's drug screens and alcohol use throughout the case. And unlike in criminal trials where ineffective assistance of counsel claims require prejudice, as does this case, making a difference in a care and protection case and child welfare case is nuanced. A difference doesn't mean that a parent has to be found fit and the child is immediately returned to her custody. It just means that the judge might see mother's unfitness in a different light, even a slightly different light, that it is temporary, not permanent, or that it's trending in the right direction. And the judge could have found my client unfit even after Dr. Mueller's testimony, but might have resorted to a different disposition that was at her disposal under General Law, Chapter 119(26), such as a guardianship or permanent custody to the grandmother, while remaining my client's rights or preserving my client's rights.
Well, I would have thought, counsel, I think I understand where you're heading. I would have thought the most important witness on her sobriety is the mother. And the judge heard from the mother at length. And so this argument is really that there was another witness who was available, who might have had some information that mattered, that the judge refused to hear from. At least that's the way I see it. Am I missing something?
No, I mean, of course, the most important one, and I do submit that mother's substance abuse counselor, the credentials are unrivaled. There was no other evidence submitted beyond her clinical diagnosis of substance opioid disorder, which the judge found she had been managing quite.
Is there any evidence that Mueller even knew about her alcohol abuse?
Yes, because he was the one conducting her drug and alcohol screen. So he had some of the positive screens that were in the record, I believe, come from his screen. So he's aware that she was using alcohol and tested. And so the judge relies on two things in finding that Dr. Muno's testimony would have been, I guess, unwarranted. So it wouldn't have made a difference in her mind. The first is that she summarily speculates that mother may not have been forthcoming with him. But there's nothing in the record to support that mother was not forthcoming to Dr. Munoz. There's nothing in his affidavit that was contradictory to anything that she said or did. And there's certainly nothing in the evidence that was submitted that would suggest it was inconsistent with what mother said or did. So the surmise that Dr. Munoz may have been forthcoming just doesn't itself have any support in the record. But secondly,
well, it has support in the record. He found that she was not credible and that she did not tell the truth to a number of people throughout her findings. So she's not speculating.
Well, she's interpreting.
Did we lose my?
We lost your audio. At least I did. Just for a second.
Yeah, now I'm getting a note that my internet connection is unstable. I apologize. All I said, you know what, it's not that important. My point was, you say there was no evidence in the record. The judge clearly found many instances where she had not been forthcoming to others. Isn't that evidence?
Not to Dr. Mueller. And I think that's critical because if Dr. Mueller was subjected to cross-examination, direct examination, and testified fully to what he knew, then it might have had a different outcome. To certainly surmise from other instances that mother might not have been forthright with other people in the record at different times throughout the case doesn't necessarily extrapolate that she was by de facto dishonest or not forthcoming with her treating physician. And because of that, the other prong to that was that she was back to her footnote saying that her substance abuse issues were because they were longstanding and she should have shown more insight. But that's exactly who is the best witness to testify on her behalf as to the ongoing nature of her substance abuse.
Okay, what do we make about the fact that Dr. Molnar's affidavit doesn't mention alcohol at all, and that's plainly, rightly or wrongly, one of the primary concerns of the judge?
Well, he does mention that substance abuse in general, she has ups and downs, as many patients do, but overall, he continues to make steady progress, has not relapsed into opioid addiction in over 7 years. So again, there was nothing in the record that mother, again, I'm not condoning that, you know, using alcohol in her condition was probably wise, but there was nothing in the record that it in and of itself would result in a greater problem or care for her, or the inability to, you know, care for her child at some point. The underlying diagnosis is for substance opioid disorder, which again, the judge found that was being credibly managed. The other use of other substances were sporadic, and there was nothing in it that would show that it was imminent result in either relapse on her opioid or a clinical condition that required. So there was no clinical evidence that her alcohol use was a diagnosis. In fact, two of the witnesses that weren't called, Dr. Kimball, had assessed that mother was at low risk of alcoholism at one point. And the other expert, Dr. Tobin, said he didn't have a clear grasp of her substance use level. So it's not as, the underlying finding could have been negated or put into a slightly positive or different light, I should say, from the testimony of her treating physician and substance abuse counselor. And for counsel to not even interview.
Is there any evidence in the record as to whether she drove an automobile?
Did she have a license, or did she? There's nothing in the record that she had any criminal behaviors with alcohol, like a GUI.
No, there isn't. That's hence my question. Is there any evidence that she drove?
I can only speculate based on her geographic location. I don't know how getting around Springfield is easy through public transportation, so it might be in Boston. I don't know if there's any evidence one way or the other that she drove. And if there is, I apologize. It's quite a voluminous record, and I have 3 arguments this week, so it's not an excuse not to know this inside out. But nothing jumps out at me that she had any criminal behavior records that from alcohol use. And so again, back to the nuanced nature of the outcomes of these cases is that Dr. Muna's testimony or the other evidence that was neglected to be introduced by her trial counsel could have swung the pendulum, even if it's away from the termination of parental rights decree that the judge ultimately entered. Again, there were other factors she relied on, but she clearly states that the substance use issue was that tipping point for her. And had there been any difference in that, the implication is that the other factors were not significant enough to terminate her parental rights.
How do we get around the fact? I mean, normally when we do an ineffectiveness, the jury's gone. There's no way to know. We just got to figure out how it affected them. But here we have the actual decision maker telling us, no, still would have done the same thing. How do we get around that as far as?
Because that would extinguish appellate review. In adoption of Aziza, the trial judge made the exact same conclusion, and the appeals court decided otherwise. So I think, again, leaving it to the decision maker to decide whether it would make a difference is important. That's why we go back to the trial court first when you raise an ineffective assistance of counsel claim to see whether or not that could have made a difference and avoid the burden in the appeals court with the appellate review on the issue. But that decision ultimately would escape or evade appellate review if it was given a absolute discretion, if you would. And so I do think that when you look at the underlying reasons for why it wouldn't make a difference, I think her own findings belie that, because this is exactly the type of testimony that would have addressed her concerns with mother's so-called non-standing substance abuse history and whether or not she was showing insight into that. And she also bases part of that decision on a credibility determination that has no foundation in the record as it applies to Dr. Milner and his treatment of mother. And so
what's the law on the mother having chronically no means of support? I mean, we're told that you don't sever a relationship with a child because someone is poor. But if they don't have the ability to care for the child, surely that's relevant.
it is a relevant factor for determining whether a mother is unfit to some degree, of course, I think, but it also is consistent with the judge's own case summary remark that this her homelessness or her not homelessness, her spotty employment history and housing situation themselves would not be enough to terminate parental rights, but it is a byproduct of a symptom of her substance abuse disorder, which again, the only diagnosed substance abuse disorder she had, the judge found she was managing and had under control. So again, while it may be unwise for a parent to use other substances, even sporadically or occasionally, there must be evidence in the record that would support that this in and of itself would lead to a greater problem, or itself was the problem. And I mean a greater problem, like relapsing on other drugs. So that isn't here. And again, the judge—
Was there evidence in the record that if child were restored to mother, she would be able to live with her family again?
Well, I don't know if that was explored at the time that these decisions were being made. Unfortunately, custody disputes in this case, when the grandmother was the pre-adoptive parent, obviously they become emotionally charged. People get upset with each other. Usually those types of relationships get repaired once some of these decisions, once the cases have subsided. So could she have? She has historically been living with her parents. And to be frank, I'm not so sure from the record what the level of assistance that the department made in terms of helping with the housing. So if there is housing and employment issues, those are correctable. She did actually have, I believe, housing for 3 years at the time of trial. She had been residing in the same apartment. So the housing wasn't, I think, in jeopardy. And unfortunately, I mean, people are in the midst of a pandemic. People are, well, this predates that, of course, but people do have bumps in the roads in terms of economics, but she does have a college degree. She had a history of employment. She also has other issues. I mean, public assistance is something that could be available to her if she had custody of her child. These are not very readily explored, but just to delve a little bit into the judge's mindset is that these weren't factors that she would have relied upon in terminating mother's rights, but they were symptomatic of other issues. And those other issues could have been dispelled or put into context with just better lawyering by calling a key witness, if not the most important witness, on her substance abuse history and treatment. He has a very unrivaled credentials in this case. I mean, the only testimony we heard from is from a social worker, the mother herself, and the grandmother, but no clinicians or no one with any expert background. An expert background or medical opinion, even if it doesn't have to be compelling, doesn't even have to be great. It just has to be enough information to the judge to wonder if this decision is set on solid ground, or is there more that could have been done for this family before taking this extreme step.
All right. If there's any further questions, thank you very much for your argument. And we'll hear now from the department, from Special Assistant Attorney General Salcedo. You have the floor.
Your Honor, may it please the court, Richard Salcedo on behalf of the Department of Children and Families. The trial judge in this matter focused on a number of factors in determining mother's unfitness. Certainly her substance abuse was one factor that was focused upon. However, Dr. Mueller was essentially the doctor who was treating her opioid addiction. She had seen him consistently, the court found. She had been treating with Subutex and Suboxone for a number of years. Court found that she had not tested positive for opioids in several years as well, and that she was consistent in meeting or treating with him. The court fully considered in the post-trial proceedings, Dr. Mueller's affidavit, and the court concluded that none of the facts that were buried in the affidavit would have changed the outcome of the case. None of those facts were in dispute. The court made specific findings about each of them. What was concerning for the department and to the court as well were the number of positive screens that occurred later or more recently in the case. And the evidence does not show that Dr. Mueller, for example, was aware that mother had tested positive for alcohol during first or just before the first day of trial.
Alcohol is not illegal. The last time I looked.
No, Your Honor, you're correct. It's not.
And where is the proof of alcohol intoxication? Is there any evidence anywhere in the record that alcohol actually impaired her?
What was concerning to the court, even though mother minimized her alcohol use as just social drinking or occasional, what was concerning to the department was that it was occurring during the day before meetings with the department. She smelled of alcohol.
Well, what is it? It is she smelled of alcohol. I think there was one reference to a concern that she was showing the effects of it. But we don't take a child away from their parent because they drink alcohol during the day, do we? That would seem to me to be rather extreme. I haven't seen that one in our cases yet.
Well, I think given mother's history of parenting this child, I think the fact that she was continuing to drink alcohol during these periods of time when she was seeking to have custody of the child restored to her, there was also.
Did she have some stipulation that said in her service, in her agreement that said she could not even drink alcohol? She couldn't. There wasn't, right?
Mother had an opportunity in April of 2018. The court found there was a visit that she appeared for and appeared to be under the influence, and the social worker said, you know, if you want the visit to go forward, let's just have you screened at a nearby facility. Mother said that she would do that, and she failed to return.
So that's one instance. I thank you for reminding me of that. And I think there might have been another instance where the social worker said in speaking to her on the phone, she sounded like she was impaired, right?
Correct. But the court also...
it's just, you know, one of the reasons I asked whether she drove is because this is a very low level of evidence of alcohol abuse as opposed to alcohol use. You've given me two instances over the course of years. And, you know, you usually see other things with someone who can't control their alcohol intake.
Well, also of serious concern to the department and to the court was mother's domestic violence history with father. She exposed the child. This is shortly after the child was placed in her custody when she had the opportunity to parent her. The department clearly, specifically instructed mother not to allow father to have or be in a caretaking role for the child. Mother signed a service plan and said that she would not do so, and she did. And there was a violent episode that occurred, and the police were called.
It was a violent episode. It wasn't violent between parents or between parent and child. It was property violence, right?
Yes, but the court specifically found that the child was in an extremely unsafe situation given the enraged state of mind of the father. And despite this violent episode,
What year, remind me which year that was. Is that 2016?
It was, yes. And it's what led to the initial removal.
That was neglect. That's evidence of neglect. She's got the child with someone who loses control of themselves, damages all kinds of things within the home.
And despite this violent episode, very short time afterwards, mother was in contact with father again. There was a incident where father was in the home, mother and father were arguing, and the police again were called to the home. Mother had father exit through a rear door. And then there's other even more concerning evidence of mother's involvement in a relationship with another violent offender. In November of 2017, she was assaulted by this individual. She required treatment at the hospital afterwards. And despite this violent episode, she returned to have dinner with this individual again and was assaulted a second time. And despite both incidents, mother continued to have regular contact with this individual. The court found, based upon the evidence that was admitted, that she continued to have a relationship with him at the time, or appeared to have a relationship with him at the time of trial. As was mentioned earlier as well, the court also considered.
Counselor, time has expired, so
okay.
Unless my colleagues have any questions. Thank you very much.
Thank you.
Very helpful. And we'll hear for counsel for the child, Attorney Foster. You have the floor.
Good afternoon, Your Honors. May it please the court, Attorney Catherine Foster on behalf of the appellee child. This is a unique case. Even though mother is unfit, she and the child are well bonded. The child and her mother, with the help of the maternal grandparents, see each other regularly and have a loving and affectionate relationship. Unfortunately, a bond and even an affection are not enough to overcome the evidence of mother's parental unfitness. And from the child's perspective, there are two reasons for that. The first is mother's failure to gain any insight into the problem of domestic violence in her relationships. And the second is that even though trial counsel's representation was demonstrably poor, it did not ultimately prejudice mother.
How can we know that in this kind of a case?
Well, my understanding is that the two arguments relate to two witnesses, Dr. Tobin and Dr. Mueller. Dr. Mueller, we've talked about a little bit already, and it seems that really what mother was concerned about was that the evidence be framed in testimony in a more positive light by Dr. Mueller. It seems that Dr. Mueller does have a positive working relationship with his client. And so, like in his affidavit, he would have a positive way of expressing the facts that are already in evidence. But there's no
have to have expert testimony behind it, right?
Sure. Yes, Your Honor. But even testifying as an expert, there's no indication that he would have contradicted any of the evidence that was already in the case from his notes that DCF had read throughout the case and used to make determinations about. There's just no indication that he would have contradicted that, only that he would have framed it more positively. So that's the reason that I would argue.
When you say there's no indication, you mean it wasn't in the, so, I mean, suppose that he came in and he said, I've been treating her for 7 years. She comes in once a month. I have seen absolutely no evidence of substance abuse in those 7 years. The fact that she's screened positively for alcohol is not an indication to me that she has alcohol abuse issues. And I've seen no evidence of that in the way that she carries herself and in what she's done. Now, maybe this wasn't in the affidavit, I don't know. But it would seem to me that I don't think your brother has really misframed the fact that substance abuse was the driving concern of the judge, and having this person come in and say, I've seen no evidence of substance abuse, that'd be pretty important, because we have all these positive screens. I say all these, I don't know, it's a handful, right? Half a dozen maybe, but it's Klonopin, it's cocaine, it's alcohol. But is that evidence of abuse? And suppose he comes in and says, I haven't seen any evidence of abuse.
Well, my first response would be that the word polysubstance that mother disagrees with in the court's findings is a word that Dr. Mueller uses in his notes, that he's treating mother not just for opioid abuse, but for polysubstance abuse. The relapse prevention plan that she submitted to the court, she crossed out drugs and wrote alcohol. It may be that she prepared that plan while at a treatment center for 28 days that was focused on alcohol recovery that she attended in April 2018. So
Mueller's notes use the word polysubstance abuse.
That he's treating her for polysubstance abuse.
Okay.
I have that as being in the record on page 152. I guess that's why on the whole, it seems to me that he wouldn't contradict what he's already said, and that even if he would frame it differently, it makes sense that the judge couldn't see how she would find any differently. But I also wanted to talk about Dr. Tobin, because mother focuses on the recommendation in his report that mother, if she was able to focus on her sobriety and continue in counseling, and if she was able to be separated from her boyfriend, for her abusive boyfriend, for at least 6 months, that then DCF should consider reunification. And that is, a positive recommendation. It's not overwhelmingly positive, but it's a good recommendation that I understand mother wants to put focus on. But something that mother doesn't acknowledge is that if Dr. Tobin was called to testify about that recommendation, he could also be called to testify about conclusions that he made in the middle of his report. Conclusions that, mother, she tended to minimize her problems, put herself first over the needs of others, externalize blame and responsibility, was unable to modify her behavior. She has trouble coping with day-to-day responsibilities. It seems that, some of these organic considerations may be the reason why she hasn't been employed since 2011, despite having a college degree and having worked for 11 years as a paraprofessional.
The problem I have, just to put the cards on the table, is I could agree with everything you say, and I'm not sure it rises to the level of the kind of evidence that allows you to sever a parent-child relationship.
Well,
right?
and this certainly,
there are a lot of people out there who have trouble coping. There are a lot of people who drink alcohol during the day, and we don't sever their relationship with their children.
So from the child's perspective, I would focus your attention on the problem of domestic violence, because mother testified at trial that the beating and strangling that she suffered at the hands of her boyfriend did not impact her daughter, because her daughter had never met the abuser. But a few sentences later, mother admitted that she brought that abusive boyfriend to her daughter's birthday party. She was already exposing her abuser to her daughter before she had custody. In the weeks and months before trial, mother's abuser liked or commented on the child's pictures on mother's Facebook page. Mother testified that through her work at the Elizabeth Freeman Center and Domestic Violence Counseling, she knew she should cut off all contact with her abuser, but also that if she ran into him on the street, she wouldn't turn around and walk away, but that she might actually hold his hand.
Cool.
And these,
I think Counselor will have to leave it at that unless Mike.
Thank you.
Have any more questions?
Just one thing. Would you, do you disagree that the judge's decision appeared to be driven by the substance abuse issue or the alcohol issue? Rather than, I understand you began your argument with the domestic violence and you ended it with the domestic violence piece. Do you disagree with the notion that that was not the primary driver?
I don't think I disagree, but I disagree, I guess, with the emphasis on that to the exclusion of the whole picture. Because I think that, yeah, certainly that alone, even though that might have been the judge's biggest concern, may not have been enough. But in the context of the other problems that Mother had, she only parented her daughter for 4 months of her life. I think in the context of the other challenges presented, that termination was appropriate.
Thank you.
All right, thank you. These are always difficult cases, and this has been very helpful to the court. Great briefs, great argument. Thank you very much.
Recording. The case is now being recorded.
All right, home stretch. I'll call the last case of the day. Zoning Board of Appeals of Norwell versus the Housing Appeals Committee, number 20P244. And we will start with Attorney Galvin for the town.
Good afternoon, Your Honors. May it please the court, my name is Attorney Robert Galvin. I am counsel for the appellant, the Norwell Zoning Board of Appeals. Your Honors, this case concerns the limits of the Housing Appeals Committee's discretion to find that proposed conditions of an approval with conditions are uneconomic. The right of the Housing Appeals Committee to utilize DHCD guidelines for in substitution of actual evidence or to change the burden of proof. Errors by the Superior Court in affirming those aspects of the committee's decision, and what we view as a conflict between the Superior Court decisions from 2017 and 2019. In its February 5th, 2019 decision, the Superior Court ruled that the Housing Appeals Committee decision in the White Barn Lane matter was supported by the substantial evidence. The court cited a DHCD guideline that created a rebuttable presumption shifting the burden of proof that a developer will not be able to achieve a reasonable return if a condition decreases the number of units in a project by more than 5%. It also found that the project engineer's testimony to be credible that the refusal to waive a local nitrogen loading bylaw resulted in only 19 units of the proposed 40 units. Lastly, the Superior Court said that the board had cited no evidence that if permitted to construct 26 units, the project would then be rendered economic. In this appeal on the distinct issues that we've raised, we are asking the appeals court to annul the decision of the Superior Court, remand the matter to the committee to consider these matters without the use of the guidelines, without placing the burden on the board on the issue of economics. As it relates to the guidelines issue, which we think is certainly the one of the most important issues on this appeal, the court found that there was no merit to the argument that the Department of Housing Community guidelines do not carry the force of law and the HAC should not have relied upon them. And the only explanation—
Putting aside the guideline altogether, wasn't the evidence sufficient to establish that it was uneconomic?
We would suggest not, Your Honor, and I guess I'll skip to that then. We would suggest that the Superior Court did not meaningfully review the board's contentions on the appeal, the 30A appeal. Instead, the Superior Court cited the fact that the HAC credited the project manager, John Sullivan, and the project engineer, Brad McKenzie, that the maintenance of the local bylaw limited the project to only 19 units. And while I certainly understand that the Superior Court must ordinarily defer to findings of fact, as the committee was in a position to evaluate the credibility of the witness, in this case, the board really feels there was an abuse of discretion by the committee. First of all, the committee was clearly affected by the belief that it was obligated to follow the guidelines. Second of all, the evidence.
I got to tell you, maybe you think that from your hearing, but that did not jump out at me from what I read in the decisions of either the Housing Appeals Court or the Superior Court. Each of them talk about the guidelines as a second reason. Each of them discuss the facts that were put in evidence about what the pro forma was and how the pro forma would be impacted by only having 19 units. So to spend a lot of time on the presumption before you've addressed the question of the evidence that was before them, it seems to me it's not going to be terribly persuasive to me, because I don't see the guideline as driving either one of those decisions. Am I wrong about that?
I respectfully suggest that you are, Your Honor. And the reason is, although White Barn Lane argued that it was in the alternative, the guidelines dictated the shifting of the burden of proof, the Housing Appeals Committee did not. It didn't find one more persuasive than the other, and it acted as if both were equally persuasive as to why the burden should shift to the board. I looked very carefully at the decision of the committee, and I looked very carefully at the decision of the Superior Court, and I would suggest that you could not find that one was primary and the other one was secondary. They were, in our view, placed on an equal footing. Now, even assuming that.
Was that an argument that says if the Housing Appeals Committee was wrong about one of those two, then the decision can't be affirmed? That's what I'm hearing you say.
I think that they were inextricably connected to one another, Your Honor, and that's the only way I can possibly read that decision, because I just can't see where the committee said secondarily or in the alternative. What it did say is that White Barn Lane was arguing in the alternative. So for me it's impossible for me to untwine or undecipher that, because it's just not clear based on the committee's decision. But just assuming that we're talking about the evidence in another.
I think I'd like you to, I'm reading what the Housing Appeals Committee said, and I don't read what you just said. I read, therefore, on this ground as well, and it comes after the word finally at the end of a lengthy conversation that they previously had about what the evidence was that was actually presented about the economic impact. So let's go back to the economic impact evidence. There's a place in your brief where you suggest that the evidence of economic impact was insufficient, that it was not sufficient to show that it was uneconomic. But as I understand it, this gentleman, Mr. Sullivan, who's the developer, testified to a pro forma based on 19 units that showed that he would suffer a loss equal to 5% of cost.
Yes.
So what is wrong with the Housing Appeals Committee, after taking 5 days of evidence or however many it was, coming to the conclusion that that was credible?
Well, Your Honor, I think on cross-examination, the person with most knowledge regarding whether that was whether that was actually true or not was Mr. McKenzie, the project design engineer. And on cross-examination, Mr. McKenzie admitted that with the use of alternative technologies, they could comply with the local bylaw and increase the number of units between 22 and 26. So,
Counsel, he also testified that even with 40 units, they don't get to 15% profit. So why is it unreasonable to think that at 26 units, it's going to be below 15%?
Well, that kind of gets to another issue. We were not provided the pro forma for the 40-unit project, something that our financial expert had been looking for all the way along. The only pro forma that we were provided was for the 19-unit project, which no, our financial expert said was not reliable, although some of the underlying methodologies were appropriate. And I think that it was fairly clear that 26 is.
If you were not provided with the pro forma for the 40-unit project,
we were not.
Then how could Justice Ditkoff just ask you a question about a pro forma for the 40-unit project?
I didn't ask about a pro forma. I just asked about testimony.
It was just testimony. Oh, okay.
Yeah, Your Honors, we were not provided the 40-unit pro forma.
So what's your remedy if you don't have that information? What was your remedy?
Well, we were raising these issues all the way along. That
sounds to me like a discovery problem. I don't see I mean, you had discovery available to you in the Superior Court action, definitely. I don't see an assignment of error that you didn't get the discovery you were entitled to.
Well,
could you deny it based on that? Could you?
No. I mean, look at the Norwell Zoning Board of Appeals has had probably a half a dozen to a dozen 40Bs over the years, and the board has yet to deny a project. The board, it attempts as best it can with under the existing statutory and regulatory framework to endeavor to approve these housing units because the town is below its.
They've had one reversed because of the way they approved it, and then you've got this one. So I'm not sure that I'm not sure you're on a pedestal with that argument, counsel.
Well, look, Your Honors, I think it's pretty clear that the burden was always on the applicant to show that the board's conditions rendered the project uneconomic. And the reality is the evidence at the Housing Appeals Committee and the evidence that was reviewed by the Superior Court showed that the developer's pro forma at 19 was wrong. And it was admittedly wrong. And not only.
And the reason you say it was wrong, I want to make sure I understand your argument. The reason you say it was wrong was because, in fact, they could have gotten more units.
Well, we had an admission by the applicant's engineer that they could get as many as 26 units. And that was
if they employed a different kind of nitrogen addressing technology, right?
Correct, Your Honor. Correct, Your Honor.
And was there any evidence as to what that different kind of technology would cost?
I'm sorry, Your Honor. I don't recall that.
Did you present a witness who addressed?
I did, Your Honor. I did, Your Honor.
Did that witness put on evidence of actually they could get 26 using this technology, and here's how it would affect the pro forma that they presented?
I think that would involve the interplay of two witnesses, Ms. Sanders and Mr. Cheshire. And Mr. Cheshire clearly testified, and we had an admission that 26 units could be built. And Ms. Sanders was questioning the entire accuracy of the pro forma based upon what Mr. Cheshire had concluded and what we believe we gained as an admission.
You didn't answer my question, counsel. My question was there evidence as to, if you use this alternative technology, what the cost of the alternative technology would be and how it would impact a pro forma?
I'm not trying to be evasive, Your Honor. The answer is I do not believe so.
Thank you.
Okay.
Wouldn't it have been your burden under the circumstances?
No, Your Honor.
Now, why is that? If they come in and say it's uneconomic, here's our new pro forma, and you say either you're right, that's your new pro forma, or you're wrong, that pro forma is inaccurate, you're making assumptions in that pro forma that are wrong. Why doesn't the burden then shift to you?
Well, Your Honor, again, we proved that their pro forma was inaccurate as it related to the conditions of approval, and we gained that by a concession that their engineer made and that our expert offered evidence on. And we think that they didn't meet their burden as a result of the inaccuracy about the conclusions made by the developer and his engineer on cross-examination. And I would suggest that that type of information, coupled with the record is replete with admissions by Mr. Sullivan that he hadn't even considered the economic effect of dozens of other considerations, we feel that the burden never shifts to the town under the shifting burden. And, it was so apparent that the developer was wrong here. Even their counsel intervened at one point halt the questioning, claiming it wasn't about any individual conditions.
I guess
So
what I'm hearing is this. You impose a restriction on how much nitrogen can be discharged,
yes, Your
right?
Honor.
They say by failing to waive that, we can't get 40 units, we can only get 19. Here's a pro forma for 19. You say, that's not really true. You actually, if you change the technology that you use to address the nitrogen problem, could get anywhere from 22 to 26. It seems to me that's only a partial response, because if it was prohibitively expensive to change the technology that you're using, then your response is worthless. So it seems to me that if you're going to say your pro forma is wrong, at some point you have to come forward with that kind of evidence. You should be using technology X instead of technology Y.
Well, Your Honor, I think that's exactly what we were telling the committee. We were telling them that they didn't evaluate this properly, and the information they were relied upon to establishing the economic impact of the conditions was wrong. And we feel that cannot ever be logically viewed as substantial evidence, because no one would ever reasonably rely upon evidence that was wrong in order to substantiate their burden.
What about McKenzie testifying that it would still be uneconomical with the nitrogen system in 26 units? Why can't the committee credit that? It's not uncontroverted.
Well, I think that, number one, he was relying upon Mr. Sullivan's demonstration on a sketch plan that they couldn't modify the plan. And it wasn't as a result of any meaningful review of the plan itself or how more units could be obtained there. Your Honor, I do think that the guideline argument is inextricably combined, and I'll rest on my brief because I know my time is expiring, but this wasn't a matter of an omission. This wasn't an ambiguity in the regulations, and this guideline, it's impossible to take that out of the mix here. And
so is it your position that the guideline issue needs to be resolved in order to properly decide this case?
I believe it does, because it wasn't in an alternative theory by the committee, and it's impossible to extricate these arguments from one another.
All right, thank you very much. That was very helpful. We'll turn now to counsel for the developer. Attorney Croha, the floor is yours.
Yes, good afternoon, Your Honors. May it please the court. I'll jump right in to follow up on some of the back and forth on the economics.
Just hold on a second. It should be 12 minutes.
I apologize.
All right.
All right, thank you. The DHCD guidelines were an alternative position, and we can go into detail on that, but clearly the committee found on page 15 of their decision that the developer had produced sufficient evidence that the 19 units would result in a loss, and they determined the project was uneconomic based on that testimony alone. During the proceeding, the parties had agreed that the standard for whether a project was uneconomic was 15%, which is a recognized standard. And even—
Just help me, is that 15% over cost? It's not 15% on equity, right? It's 15% on cost?
Correct, 15% on cost. So the pro forma that was produced had a loss of approximately 5%. And the engineer did testify during cross-examination that if the wastewater system were redesigned, as the conversation was, then it would be possible to build 22 to 26 units. But the developers, the main proponent, had testified that it would still result in a loss. And the committee properly credited that testimony. And to back up on the economics, this is a process where we've been 14 years since we filed the application for a company.
Can I just back you up for a second? What was the evidence where he said, well, it would still result in a loss at 22 to 26 units? How was that put in? Was it put in affirmatively, or was it put in on cross-examination with just as a sort of an offhand remark?
It was put in during cross-examination. It was volume 3 at page 147. it was a cross-examination of John Sullivan, and there's testimony during the cross-examination of both Mr. McKenzie and Mr. Sullivan that talks about Mr. Sullivan's familiarity with wastewater projects. And there isn't a rigid detail of the costs and the different aspects of it, but it was a response. Mr. Sullivan clearly knew the project well and knew that there was a substantial loss for 19 units and that even adding a few units would still be a loss. And even with that, the economic analysis and the condition analysis are two different parts of the question. And there's cases such as the Amesbury case for the SJC that talk about how there are two different steps. You look at the economics first, and then you look at the conditions. And the board can't redesign a project in order to change the economics. They have to look at the project as proposed and issue conditions that they find are appropriate.
I don't understand what that means, the board can't redesign the project. I mean, the language, if what you're trying to say is we weren't required to come up with a better way to handle our nitrogen than what we proposed, that doesn't make sense to me, because I'm looking at a statute that defines uneconomic as any condition to the extent that it makes it impossible for a nonprofit organization to realize a reasonable return. The statutory language is impossible, which means that if it's possible, and I would add the word reasonably before possible, that you should be considering that. You can't simply say, well, we choose to handle our nitrogen this way, and so now you've reduced us to 19 units. Can you?
And I think that there's more to that answer than what I'm trying to say here. But what I'm trying to say is that the project as proposed is the way that it's reviewed by the board. Are there a host of different ways that could be put in? Yes, there are. And there's different ways to go back and forth on that. But here.
Wouldn't that make every condition? I mean, every condition would require some change in the plan. If you're saying you don't ever have to change the plan, wouldn't any condition automatically be invalid?
Yes, Your Honor. I'm not saying that you can't have a change in the plan to incorporate a validly put in condition, but there's two separate aspects of it. One is the condition valid, and that's the second test to the economics. The Housing Appeals Committee found that the nitrogen condition was not justified by local concerns, and that issue has not been appealed. So
they found that the local concerns didn't overrule the need for housing, but if they don't make it uneconomic, then you lose, because that's the first thing you have to prove, that the conditions made it uneconomic.
Correct. Correct. The economic analysis.
Why is it that, so yes, so why isn't it your obligation when confronted with a condition such as this to look at reasonable alternatives to your design that could improve the economics of your project?
And Your Honor, I respectfully, during the hearing process, the 5-day hearing process, that was part of what was looked at. Mr. Sullivan did respond to the economics of the additional units on a different treatment, and Mr. McKenzie didn't try to hide the fact that there might be other technologies that could increase it. But even with that, you're still looking at a project that the testimony before the committee, to which their findings are afforded great deference, that the project was still economic.
Well, still uneconomic. Give me that transcript site again to when Sullivan said, if I had to do 22 to 26 units. I'm sorry, I'm
Volume 3, 147.
What do we do with the fact that the project is uneconomic under any circumstances? And the statute says the conditions have to make it uneconomic.
So at the time, the regulations didn't talk about it. Now there's a portion of the regulations that talk about this. It's clear that the developer doesn't need to propose a project that's economic to begin with. They can propose one that's uneconomic. And there was committee decision at the time that said that if a project is proposed as uneconomic, then the developer needs to show a causal connection between the condition that causes the project to be more uneconomic. And the Housing Appeals Committee and the regulations deal with the issues that are up for debate during the hearing through a pre-hearing order that sets out what the issues in dispute are.
You have a site for regulation?
Yes, let's see, 56.06 7D3. And the pre-hearing order in this case did list the decision that talked about this causal connection as a part of the issues in dispute, but the pre-hearing order stated that evidence on that causal connection was on the board. And so the Housing Appeals Committee in their decision did say that if there's a causal connection question, then it was up to the board to produce evidence on that aspect. And so they really didn't look at it in detail. But even if they had, we're looking at a 40-unit project that's taken down to 19 under the developer's pro forma, or 26 if you consider the changed wastewater treatment. So it would still be something that would satisfy the causal connection that was in play at that point. The issue of the DHCD guidelines is just a red herring. There's enough evidence on the economic aspect of it. And the project has been going on, like I said, 14 years at this point. The 40B process was intended to be a streamlined process for approvals. And the 1969 report before the Comprehensive Permit Act was put into place talks about how it's needed to make it more feasible to do these projects so that not just every developer who is so determined and well-financed can go through this process. This appeal has taken another 2 years out of the project, and the board has raised two issues that really have no merit. The planning board issue that we haven't talked much about, but there's two other Superior Court decisions that have preclusive effect and are not on appeal here. The 2017 decision that was in a totally separate case, and then even the board and the abutters in this case had filed a motion for reconsideration asking Judge Chin, who decided the decision that's on appeal here, to reinterpret how he had set forth the 2017 planning board decision, which was found entirely in White Barn's favor. And so the deciding judge, Judge Kelly of the 2017 decision, wrote the decision on the motion for reconsideration and said, no, Judge Chin got it right. White Barn has already filed 2 applications to the planning board, and they don't need to file a 3rd application. There's no abutter consent required, because the way that that would be triggered is if there was a change to the marketability of title. So we asked the court, we put in our brief about attorney's fees. The 40B process was created to bring forward affordable housing, to make it more feasible. And the towns need to be reminded that they can't render 40B meaningless.
Can I interrupt you for a second? I'm looking at page 147 of the appendix now. And one of the things I'm struck by is, you know, your client doesn't really go through an economic analysis. Instead, he says something that on its face is very understandable. He says, well, we were already under 15%. I know what those things cost. There's no way that it would have made sense for me to build a wastewater treatment plant. How come you didn't provide the pro forma for 40 units?
There were some earlier there's a series of standards under the regulations that talk about when a board can request a pro forma during the local hearing process. And when the decision was rendered by the Zoning Board of Appeals and White Barn appealed it to the Housing Appeals Committee, the zoning board had raised the issue. We didn't have a pro forma during the local hearing. Why
didn't you provide it to them in the Superior Court action then?
It was never asked for once it got to the committee. It was really never asked for beyond the local hearings. And at that point, through the committee testimony, we had provided.
Because you come in and you say, this is really unreasonable what they're doing, and you ought to award fees. And yet I'm still struggling with the quality of your evidence on what was an observable, anticipatable potential issue, which is, what about building a wastewater treatment that would improve your nitrogen content? And the answer that your witness gives is based on a pro forma that was never provided. I'm just making an observation for purposes of trying to sort through this. I think we understand your positions. I understand that.
The only board testimony that came out of it was supported our evidence on the costs and revenue factors that were on the 19. So under the pre-hearing order, which set the issues that were in dispute at the committee, our burden was to show that the conditions rendered the project uneconomic by providing the 19-unit pro forma that satisfied the question and showed the loss of more than $1 million, which was the 5% loss through that process.
All right. I think I'll have to leave it there unless there's any further questions. Thank you very much. It's very helpful. And finally, last advocate for the day, we have Assistant Attorney General Kaplan for 3 minutes.
Good afternoon. Good afternoon, Your Honors. Elizabeth Kaplan for the Housing Appeals Committee. This case can be affirmed based solely on the evidence that the developer presented showing that the project as conditioned would be reduced to 19 units, and the project at that size would produce a financial loss. Specifically on page 15 of the committee's decision, it says, while the evidence presented by the developer is not extensive, White Barn has presented sufficient evidence to support a finding that a 19-unit project would produce a loss. And then the committee goes on to consider other evidence offered for both the developer and the board on project economics, and ultimately finds that the developer has met its burden to show that the project is uneconomic as conditioned. So therefore, I disagree with Attorney Galvin's position that in fact, this court must consider the 5% rule as inexplicably intertwined. I think, frankly, Your Honors can affirm solely on the basis of substantial evidence. However, at the time that this case was before the committee, the DHCD Chapter 40B guidelines also included a definition of reasonable return that established a presumption that where the permit conditions reduced a project size by more than 5%, the conditions made the project uneconomic. The DHCD guidelines no longer include that definition, but because the guideline was applicable at the time that this case was before the committee and the developer raised it as an argument, the committee essentially considered it simply as a point in the developer's favor.
The statute says that the HAC has to find that the conditions make the project uneconomic. How can they, by guideline, not even regulation, instead don't do that, but just say, well, if the other side doesn't disprove it under these circumstances, we just don't have to find it?
I don't think respectfully that that's what the committee did here. First of all, the regulations set forth the burdens of proof. And as I just explained, the committee walked through the developers, the evidence that the developer presented that met the burden of proof that they had to show that the project was uneconomic. The only thing that DHCD did here was establish essentially a policy guideline filling in what was at the time a gap in the regulations as to the definition of reasonable return, and basically stating that it was the parent agency, DHCD's position, that there can be a presumption that the project will not generate a reasonable return where there is a significant reduction in the project size. In that guideline, it was 5%. But as I noted, for Your Honors, this guideline is no longer in force and frankly doesn't even need to be considered in order to address whether or not there was substantial evidence.
The real question in my mind is to whether it was rational for the reasons that are identified in the brief of your opponent, which is all it does is encourage somebody to overestimate what their units are so that they've got an automatic burden shift placed when they have to litigate the thing. And it has to be rational, right?
It has to be a reasonable interpretation of the statute and a reasonable interpretation of the committee's regs. And to the extent that it is reasonable, it is entitled to deference. Now, that being said, I would like to mention in response to Justice Englander's question that this is actually the only application of this guideline that the committee ever did before the guideline was changed. And this was a 52% size reduction. So there's no evidence identified by the board that in fact, this project was improperly padded in order to trigger the 5% reduction. I just don't think that is a reasonable conclusion based on this evidence, nor is it what the committee ultimately found.
Case of last impression then. Okay, well, unless there's any further questions, thank you all. This is a really interesting case, and this has been really helpful. The briefing and the argument's been really, really helpful to the court. That concludes our sitting for today. I'd like to thank all the lawyers who appeared in front of us. I'd like to thank our timekeeper and clerk, who's kept us running despite all our many computer problems. And of course, I'd always like to thank Clerk Joe Stanton and his staff that make this possible and enabled us to get running when the pandemic started on Zoom faster than anyone would have believed possible. And with that, court will stand adjourned until 9:30 a.m. tomorrow on both YouTube channels.